So I never turned the microphone on. Guess my executive producer is doing something else. All right. Those of you who just tuned in, sorry, you picked the right spot. Those of you who were here and were listening to nothing, I apologize. What I will do is when I post the video, I will put up the what am I going to do? I'm going to put up the timestamp as when to avoid the video. In fact, there's something I have to do right now. I just realized I never changed this. Oh, why did I do that? Okay, there we go. I'll have to change that midstream, but at least people who come here later won't be fooled by the wrong title. All right, once again, I'm Hat. Welcome to AHNC, All Hat No Cattle. Today we're doing the reading of the first half of James Rybicki's closed-door testimony to the House Judiciary and House Oversight Committee from January of 2018. Rybicki was the chief of staff to the director of the FBI. He has since quit, and many would say under disgrace. I would as one of them. But let's get into this and see what he has to say about the mid-year exam investigation. Let me check my Zoom here. That's better. All right. Bring this down a little bit. Good. All right. Committee on the Judiciary, U.S. House of Representatives, Washington, D.C. Interview. Cat. Sorry, folks. Executive session, Committee on the Judiciary, joint with Committee on Government Reform and Oversight, U.S. House of Representatives, Washington, D.C. Interview of James Rybicki. Thursday, January 18, 2018. Commencing at 10:15 a.m. Chairman Goodlatte. All right, let's go on the record. This is a transcribed interview of James Rybicki, Chief of Staff to the Director of the Federal Bureau of Investigation. Chairman Gowdy and I requested this interview as part of a joint investigation by the House Committee on the Judiciary and the House Committee on Oversight and Government Reform to conduct oversight into the Department of Justice's investigation, I wanted to say handling, of former Secretary Clinton's handling, there it is, of classified information and related matters. Would the witness please state his name and position at the FBI for the record? James Rybicki, Chief of Staff to the Director of the FBI. Goodlatte, I want to thank you for appearing here today and appreciate your willingness to appear voluntarily. It is a pleasure, Mr. Chairman. I'm Bob Goodlatte, Chairman of the Committee on the Judiciary, and I am joined today by several members of the Judiciary and Oversight and Government Reform Committees and by counsel for those committees. I will now ask everyone else from the committees who is here in the room to introduce themselves as well, starting with members of the committees. John Ratcliffe from Texas, Andy Biggs, Arizona, Ted Lieu, California, Jerry Nadler, Ranking Member from New York. Goodlatte, anything you want us to? DeSantis, Ron DeSantis, Florida. Goodlatte, did Zoe Lofgren leave? Now the staff members. We'll start with you, Ryan. Mr. Breitenbach, Ryan Breitenbach, Counsel on the Judiciary. Zach Summers, Judiciary Majority. Sean Brebbia, Oversight and Government Reform, Majority. Stephen Castor with the Government Reform Majority. Robert Parmenter, Judiciary Majority. Sheila Clark, Oversight Majority. Shelley Husband, Judiciary Committee Majority. Susan Saxman-Grooms, Oversight Minority. And horrible interviewer. Janet Kim, Oversight Minority. Janet Kim, I believe, is the one who, it's either Janet Kim or Valerie Shen, who always follows up an answer by the witness with okay. One of those two we'll see soon enough. So Janet Kim, Oversight Minority. Valerie Shen, Oversight Minority. Arya Haraharan. Ms. H. I can never pronounce her name. She is Ms. H from now on, folks. Aaron Hiller, Judiciary Minority. Perry Applebaum, Judiciary Minority. Nimit Deer, Oversight Minority. Joe Grappensberger, Judiciary Minority. Goodlat, is there someone in the back? You can still identify yourself. Mr. Redacted from the Federal Bureau of Investigation. Excuse me. Sorry about that. Family emergency. My executive producer will be stepping away. Hopefully things will be all right. Okay. It's been a weird week for family. Okay, so Ms. Redacted, excuse me, FBI. Ms. How chauvinistic of me. Okay, Goodlat says, and Mr. Rybicki has already identified himself. Now we're going to go over a bunch of stuff that's boilerplate. I'm going to just go ahead and leave it up on the screen so you can pause and read through it. It's really not anything that we need to know as far as this transcript goes. So again, you just pause here and read as you need to. Really boring stuff, and I've read it about a dozen times already doing these. Okay, we're going to have counsel for Rybicki state their name and current position. And this is Ms. Redacted, the acting deputy counsel for the litigation branch at the FBI. So it'll be interesting to see where she turns up later. Now, I don't know if any of these redactions have anything to do with last year's IG report on mid-year exam. Excuse me. Or if they have to do with this year's IG report, which should be coming out any day now, according to the press, in regards to the FISA abuses at the FISA court. So we'll have to see what we're going to get. But for right now, the acting deputy counsel for the litigation branch at the FBI, that name is redacted. Okay. Let's see. So there's a little more boilerplate right there. Some right there. Some right there. Okay, we're on the record now. Here, time to go. Good lad. All right, the time is now 10:23, and I will turn this over to Mr. Parmenter. I've got 10:14 on my clock right now, so we've got a 9-minute buffer. Let's see how this works. Rybicki, thank you, sir. Parmenter, thank you, Mr. Chairman. Good morning, Mr. Rybicki. I am Robert Parmenter. I'm Chief Counsel for Crime, Terrorism, Homeland Security, and Investigation Subcommittee at the Judiciary Committee. I'm just going to follow up on what the chairman said by, asking you a few background questions, and then, I hope that's not going to be a lot of that. We'll get into the heart of the matter, if that's okay. Absolutely. So just initially, did you review any documents to prepare for your testimony today? I did. What documents did you review? I reviewed the transcript of my interview with the Office of Special Counsel that was done on May 9th, 2017. I reviewed a couple of emails related to the matter. I reviewed Director Comey's statement of July 5th, 2017, as well as emails that he had sent around that time. And you said emails. What emails did you review? I reviewed the email that Director Comey sent to the workforce on July 5th as well, and then I reviewed some other emails. The email, I don't know if I'm going to remember all of them in particular, the email where Director Comey circulated a draft of his July 5th statement. And are you referring to the May 2nd email? I am, yes. Excuse me. Started off particularly dry today. Okay. Did you speak with anyone to prepare for today's interview or about today's interview? I did. And who did you speak with? I spoke to representatives from the Office of Congressional Affairs at the FBI, as well as the Office of General Counsel, as well as Mr. Schools from the Department of Justice. Okay? Did you speak? And who from OCA or OGC did you speak with? Rybicki. I spoke with Ms. Redacted, who is here today from the Office of General Counsel, Tricia Anderson, the Acting General Counsel of the FBI. We'll be getting to Ms. Anderson later on in these readings. I believe she's just a little over midway down, closer to the end. And I don't believe she's gone. She may have been reassigned or demoted, but I have not been able to determine that completely yet. Let's see, Mr. Brower, the Assistant Director of the Office of Congressional Affairs, Redacted with the Office of Congressional Affairs, again, Mr. Schools from the Department of Justice. I also spoke to several individuals about the fact of the interview, but nothing in preparation for the interview. So did you speak to Ms. Anderson in preparation for the interview? I did. Okay. Did you speak with her about the interview that was conducted with Mr. McCabe? So she referenced the fact of the interview not in substance though, but in form. Okay. And what did you speak about with Ms. Anderson? Sure. Certainly, we spoke about preparing for this interview today and just the format that it may take. Did you speak? You said you spoke with people about the fact of the interview. Were any of those individuals involved in the Clinton email investigation? So I spoke to the director. I'm just trying to remember. Director Ray? I'm sorry, yes. I don't know if I spoke to Mr. Bowditch, our Associate Deputy Director, about the interview or not. We had a couple telephone conversations. I just can't remember if we spoke about it or not. Excuse me. Okay. And what is your current position at the Department of Justice? I'm the Chief of Staff at the FBI. How long have you been FBI Chief of Staff? Since May of 2015. Okay. Is that a career SCS appointment? It is. The FBI has a little bit different process for SCS, but it is considered career. It's not a political position. Okay. But you serve at the pleasure of the director. Correct. Okay. And to whom did you report at the FBI? The director. Directly to the director? Correct. And so that's Director Ray in this circumstance? That is correct. And before Director Ray, you reported directly to Acting Director McCabe in the interim period of the summer, and prior to that, Director Comey. Okay. And how long was Mr. McCabe acting director? I forgot when he was officially named. It was on or about the May 9 firing of Director Comey up until Director Ray was confirmed, which I believe was either August 2 or the 4th is when he was sworn in. Okay? And as FBI Chief of Staff, how many employees do you supervise? We have, let me double check my count, approximately 6 direct reports, and then in the director's office proper, including the director's protective detail and others, there's redacted individuals. Okay, so just in case you're not familiar with corporate speak, one direct report is one person who reports directly to you. So 6 direct reports means he obviously has 6 people working directly under him who report directly to him. I used to know that as being how many people do you supervise, but that's changed completely. Now that's a whole nother ballgame. Parameter. So is anywhere from redacted, you would estimate? Rybicki. Under redacted, I would say total. Yes. Parameter. So do you supervise that many directly? No. Directly, only about 5. Only about 5. Okay. But as chief of staff, are you involved in staffing decisions, hiring decisions, reassignment decisions, either at headquarters or both at headquarters or in the field? Yes, as an advisor to the director. Okay. And how are you involved in those staffing decisions? Sure, I participate. We have formal processes for most of our promotions and hiring decisions. Some of them are discretionary, but I participate again as an advisor along with the director, the deputy director, and the associate deputy director of the FBI. So you advise on hiring decisions and other staffing matters, in particular circumstances. Okay, and like what circumstances? It depends. Again, for certain positions we have, for our executive assistant directors, our associate deputy director, and the deputy director, those are chosen by the director. They don't go through the normal career board process. For most other positions in the Bureau, for SES positions, they go before the career board. Okay, what are your other duties as chief of staff? My primary duties are to serve as an advisor to the director, to be sort of his eyes and ears on certain matters, to also run the director's office, which includes, again, the director's detail, other support positions, our executive secretariat. I also interact quite frequently with other executives, the deputy director, the associate deputy director, the executive assistant director over our branches, and in some cases, with our field commanders as well, our assistant directors in charge, and our special agents in charge. Okay, so would it be fair to say there is an administrative side to your duty and a substantive and administrative side where you're overseeing, sort of the operation of the Department of the FBI, and then an advisory side to the director himself? I think that's fair. I want to be clear on sort of how we delineate, though, if I may. Sure. Our duties. Rybicki was interrupted by Parmenter, so he basically says, how we delineate, though, if I may, our duties. So I'm a direct report to the director as well as the deputy director. Almost every other FBI employee reports up the chain of command through the deputy director, and the deputy director of the FBI oversees the operational, running of the FBI. Okay, so did any of your duties change when the FBI transitioned from Director Comey to Deputy Director McCabe, or Acting Director McCabe, and now to Director Ray? No, not substantially. Okay, where's your office physically in relation to the directors? It is as you walk in the director's suite, there is a reception area. My office is to the left. If you go to the right, there is a large conference room, and then the director's office is to the right of that. Okay, and so how frequently during a typical day do you interact with the director? It varies. I would say quite frequently. Excuse me. Okay, so more than 10 times a day, either by email or phone or in person? I would hesitate to put a number on it, but it is quite frequent. Okay, now specifically, in serving Director Comey, what were your duties for him in terms of, did you draft written materials for him? Did you prepare memoranda for him? Was there a writing component to that, like? No, it certainly happened, but it wouldn't be one of my primary duties. Okay, did you review all documents that crossed his desk or that were emailed to him? Did he generally share things like that with you? I wouldn't say all, but he would share documents with me, yes. Okay, as Chief of Staff, do you participate in discussions about, whether the FBI may decide to initiate a criminal investigation of someone suspected of committing a crime? I wouldn't say routinely. I can't think of an instance where an initiation decision came up to me for decision or to interaction. I'm just trying to think here whether that's happened. I would be hard-pressed to remember an instance where that would come up. Parmenter interrupts. Okay, Rybicki finishes for initiation. Parmenter. So, who does ultimately make the call in a typical case whether, The United States will charge someone or not charge someone. Whether they will charge someone, whether they will initiate an investigation, both. Whether there will be an initiation of an investigation, then ultimately whether there will be a recommendation for charging, and then whether there will be charges filed. Sure. I think it really depends on the circumstances in both cases. Certainly charging recommendation or charging decisions are rightfully within the Department of Justice. Right. Initiation of cases and recommendations and whether to initiate, whether to recommend, and things of that nature would be done at various levels depending on the case, often in consultation with the Department of Justice. Parmenter. Okay. And so on that subject, consultation with DOJ. What happens generally in your experience if there's disagreement between FBI and DOJ about, whether a case should be pursued either by investigation or ultimately by prosecution? Excuse me just a moment. Okay, that's better. Had to turn up my headphones a bit. Rybicki, I don't know if I can answer that in the abstract. I think it would just be dependent on the case. Okay. During your time at DOJ, have you ever been subject to an Office of Professional Responsibility proceeding? No. Are you involved or notified when other employees are investigated by OPR? Yes. You are in all cases? I don't want to say all. I get reports of investigations that OPR is initiating, but whether there are some that I haven't been notified of, I don't know. Okay. Have you ever used personal email to conduct official FBI business? I don't believe I have. There's been instances, if I have used it, I made sure that it was captured as a record. Excuse me. For instance, if FBI computers were down, DOJ computers were down, things of that nature. Okay. So do you remember, this is driving me crazy. So do you remember that specifically happening, computers being down and having to use personal email? Yes. Do you remember the context of that? I don't. I remember it happening, but I don't remember the context. Do you remember about when it happened? I don't. I can't remember the specific instance, but I can recall doing it before and making sure that it's been captured. Okay. Are you aware that anyone in your direct office or anybody you directly supervise has used personal email to conduct official business? Yes. Okay. And who has done that? I know the director has in limited circumstances. Mr. Brower. Excuse me, Jim, can you just clarify? When you say the director, do you mean the current director, the former director? Rybicki. Director Comey, in the instance that I was just referring to. Parmenter. Okay. Anyone besides Director Comey? Rybicki. I can't think of anyone else off the top of my head. And do you recall the context in which Director Comey used personal email to conduct official business? Certainly. If he was working on a document or something of that nature, he would send it from his personal email account. So he would send the document to his personal email account, work on it, and send it back? Or how would that work? I think it's fair to say that both to and from in some instances. Okay. Summers. In those instances, it would be captured the way you describe your use of personal email? Correct, to the best of my knowledge. Summers. And could you just explain the reason for having the emails captured in the official email? Rybicki. Can you just one more time? Summers. You explained that your email, when you used personal email, you had it captured in an official record. Could you explain the reason for doing that? Certainly. To, make sure it was in our official system as a government record. Summers. If you did not do that, are there criminal penalties associated with not capturing or relating to FOIA or something else? Rybicki. I don't know what the penalties are. I know as a practice it should be done. Oh, Mr. Rybicki, I'm sorry, sir. I'm sorry, sir. You damn well know what the penalties are. Give me a break. You're a high-level government employee. You've been briefed on what happens if you don't obey the Federal Records Retentions Act. You know. You sly dog. To finish up with Rybicki, I know as a practice it should be done. Parmenter, okay. So I think that takes care of most of the background stuff. Rybicki, Mr. Parmenter, if you wouldn't mind, can I? Another instance I can think of, Parmenter interrupts, sure, Rybicki, where I would have used personal if I needed to work on a document. Again, just thinking through how the director might have used it, I can think of Again, I can't think of specifics, but I know there's been an instance where I needed to read a document or something like that as well. Parmenter, okay, I'm going to apologize in advance to you here because I'm just getting over a cold. I'm trying not to cough in your general direction. Rybicki, that's okay. Parmenter, when did the FBI open its investigation of Hillary Clinton? I believe it was summer of 2015. Okay. Do you remember what month specifically? I don't sitting here. Okay. Who actually opened the investigation? I do not know. Okay. Was it someone at the FBI? That's I think that's fair, but again, I don't know who. Parmenter. Okay. What usually happens when an investigation is opened at the FBI? I don't think I can answer that in the abstract. I don't know. Okay. I guess what I mean is, are there particular forms that are submitted? Is there an approval process for opening an investigation? Who is in that approval process? Things of that nature. I'm sure there is. I don't have that level of detail for all cases we do. The Bureau does have processes for initiating investigations, but I don't have that level of detail. Okay. What was your understanding of the scope of the Clinton investigation when it was opened? Sure. I believe it was a referral from the Office of the ICIG, the Office of Inspector General for the Intelligence Community, over mishandling of classified information, potential mishandling of classified information, and it also a look at whether that information might have been compromised. Excuse me. Again, very dry mouth. Parmenter. Okay. Well, you know it's Parmenter because it says okay. There were media reports prior to the summer of 2015 about the former secretary operating a private server. Are you aware of, or did you participate in any discussions about the possibility of opening an investigation before receiving the ICIG referral? Not that I recall. Okay. Do you know whether an assessment was opened prior to the full investigation? I do not know. Did you know an investigation had been opened when it was opened? Were you notified of that? I don't know the answer to that. Oh, Rybicki, come on. You don't know if you were told that Hillary Clinton, the former Secretary of State and current presidential primary candidate, was involved in an investigation when that opened, that someone told you? Not even when, just that someone told you. You don't remember that? Jeez. Okay, Parmenter. Okay, when you learned about the investigation, do you remember approximately when that was? I do not. I took over as Chief of Staff in May of 2015. Again, my recollection is that it was the summer of 2015 when the case was opened, but I don't remember specifically. Okay, so you do recall something. Parmenter. What were you doing before you became Chief of Staff at the FBI? Rybicki. I was the Deputy Chief of Staff. You were the Deputy Chief of Staff. How long had you held that position for? Since November of 2013. Okay. Yeah, it seems, let me just say here, it seems like the FBI, if you're on the fast track, you get 2 years, approximately 2 years in a position before they move you up to the next one. It doesn't seem to me like they give you a lot of time for getting institutional memory put together. But then again, the last place my wife worked at, the only other place my wife worked at, towards the end, people were getting promotions every 15 to 18 months. So, go figure. But then again, they were running the place into the ground, so there's that. Let's see, Rybicki had been Deputy Chief of Staff since November of 2013. Summers, could we just go back for a second to the previous questions there? Who would know basically when the investigation was initiated? Rybicki interrupts. I think, Summer, to your knowledge. Rybicki, I think there was any number of individuals, but I would certainly think that the case file would reflect it. Summers, okay, so there's a case file that would have there would be initial paper documentation of the investigation being started. Is that what you're saying? I believe there would be, yes. Parmenter, when you learned about the investigation, what did you think about that? The fact that the Bureau was investigating the former Secretary of State, the current presidential candidate. What did you think, and what did the director think? What was the mood inside the FBI about that? I don't recall a specific reaction to it for me. Did you discuss it with the director? I don't recall. This is getting old, Jim. Parmenter, okay, you don't recall ever discussing it with the director. His reaction when it was opened? Or just the Clinton matter generally during the summer of 2015? I'm certain that we did discuss it. He received regular updates on it after it began, but I don't recall specific instances. Okay, how regular were the updates you received? My recollection, and I don't know when they began, was they started as roughly monthly updates for the director, and then they became more frequent after that towards the end of the investigation. Parmenter, okay, so from monthly to Rybicki, to my recollection, is biweekly, then perhaps biweekly, weekly as a regular cadence, and then other meetings as necessary. Okay, and who was involved in those meetings? Sure, there was a group that was involved in most of those settings. Would you like the positions or names? I would, please. Rybicki. So what I would call the sort of core group that met on that would certainly include the director, the deputy director of the FBI. Now, a lot of these positions changed during the course. A lot of people changed during the course of the investigation. So deputy director, I believe, was Mr. Giuliano at the beginning and then Mr. McCabe. The associate deputy director, representatives from the actual investigative team, so Peter Strzok was the lead agent that briefed the director. Redacted was the lead analyst that briefed the director. Then there were representatives from the Office of the General Counsel, typically the General Counsel himself, other representatives from the Office of General Counsel. Would you like them? Parmenter, absolutely. Rybicki, including Tricia Anderson and redacted, representatives from Mr. McCabe's office, Lisa Page, and then myself. You mentioned Lisa Page is from Mr. McCabe's office? Correct. When you said Associate Deputy Director and Deputy Director, at the time, that was the Deputy Director who was Mr. Rybicki. It started out, I believe, at the beginning, it was Mr. Giuliano, Mark Giuliano. Or is it Giuliano? I don't know. Probably Giuliano. Parmenter, followed by Mr. McCabe. Rybicki, followed by Mr. McCabe. Parmenter, what about the Associate Deputy Director? It was and is Dave Bowditch. Okay, let me see here. I think we've already done Bowditch, and even if we haven't, he's not on the list at this point in time. So you can check the back catalog and see if we've done him already or not. But he's not in the future at this point in time. Okay, that was Rybicki who said Dave Bowditch. Brower, if I can clarify, Jim, was Mr. Bowditch the Associate Deputy Director the entire time, even during Mr. Giuliano's tenure as Deputy Director? No, he came on. Again, it is one of those positions that changed. He came on after Mr. McCabe was elevated to the Deputy Director position. Okay, because does generally the Deputy Director choose the Associate Deputy Director? It is the Director's decision. It is the Director's decision. Okay, I'm going to come back to that in a minute, the updates. Sure. But just generally speaking, so you were Chief of Staff at FBI based upon your testimony during the whole Clinton investigation. Would that be fair to say? Yes, if it started after May 2015. And to your knowledge, did it start after May of 2015? That's my recollection. I have the summertime, I just don't have the exact date in mind. Okay. What was your role in the investigation to the extent you had one at the beginning? Certainly. I had no role in the actual investigation, not a member of the investigative team. I was involved in the updates as a participant in these meetings, to sit in for situational awareness for the director. Did your role evolve as the investigation progressed? I don't believe it did. I sat in on updates. I collected comments on various things, things of that nature, but I don't think it evolved substantially. Excuse me. Remember, leftist tears. Yum, 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 yum. Okay. Who was the one who was responsible for organizing the updates for the director from all the individuals you just named? Sure. So they were in that group setting. My recollection is that we had it on a regular cadence at the beginning, and then as needed, either the investigative team needed to update the director on something, or the director asked for an update. So during those meetings, was there a discussion about the sensitivity of the matter? Yes. Okay. And do you recall what was discussed? I don't recall specifics. I recall it being handled as a sensitive matter due to the nature of the investigation. Was there any discussion at all about ensuring that, any biases that may have been held by folks in the room, political biases, didn't, affect the investigation? I don't recall any specific discussions on that. Okay, so who would you say from the FBI was the point person on the Clinton investigation? Who was in charge of the investigation? Again, the lead agent who had briefed the director was Pete Strzok, and a lead analyst, redacted, with him. Do you know whether either of those individuals were responsible for actually initiating the investigation? I do not know. Okay. How many FBI agents? Actually, let me back up. Did you know the person in charge of the investigation change at any point? Not to my recollection. As far as I know, they were the same throughout. So from the date that the investigation was initiated through the date the director announced it was being closed, it was Mr. Strzok and Mr. Redacted. I believe that's correct. Okay? And who is the higher ranking of those two gentlemen? I don't recall their levels sitting here, their positions. You don't recall if one supervised the other? That's right. I just can't remember their levels within. They were both in the counterintelligence division. I just don't remember their levels. Okay? And to your knowledge, how many FBI agents were assigned to the investigation? I do not recall. I have some recollection of it being redacted. For some reason that is sticking in my head, but I actually don't know that I know the specific number. Were all of the agents of the 100 or so agents that, you remember being assigned to the investigation, were they headquarters agents? All right, let me back up here for a second. Rybicki said, I have some correct recollection of it being redacted. They redacted the number. But now Parmenter just said, were all of the agents of the 100 or so agents that you remember being assigned? So I guess Rybicki gave a specific number that's not allowed to be published, and the generic 100 or so from Parmenter was allowable. That's weird. Well, we know it was around 100. That's pretty substantial. Parmenter, were all the agents of the 100 or so agents that you remember being assigned to the investigation, were they headquarters agents? Rybicki. So just to clarify, I think they would be agents, analysts, and other FBI personnel as that 100, okay? I don't know specifically. I know some were brought over from Washington field office, and again, because of their positions, they might have been from other entities, for instance, our operational technology division at Quantico, and offices and divisions like that. And you said you brought over from Washington field office, so did the investigation actually begin at WFO? I don't know the answer to that. Okay, but agents were brought over from WFO to assist with the investigation. That is my recollection. Agents or analysts. Parmenter, agents, analysts, or other FBI personnel, correct? Correct, yes. Can you recall names and titles of all individuals you can recall from the FBI who were involved in the investigation? I don't think I could. Beyond the ones you have already given us today, like some of the agents who were brought over from WFO, I don't think I could. I might have heard their names or otherwise received, items from them, but sitting here, I don't recall any of them. You don't recall the names or the titles. I do not. Man. Okay, maybe that's not a big deal. Maybe I'm making too much out of all these I don't recalls, but they are stacking up, aren't they? Okay, back to the text. Parmenter, okay. Can you describe, let's talk about the communication between the FBI and Main Justice across the street regarding whether the FBI was going to open an investigation. What was sort of the communication before that, to the extent you're aware of it, when you were Deputy Chief of Staff, when you became Chief of Staff, and then following the opening of the investigation, What was the interaction between DOJ and FBI? Oof, that's a question. Rybicki, I don't think I have an answer to that. I don't recall knowing what that interaction was or being a part of it. Okay. So are you familiar with the term headquarters special? No. Well, I'm sorry. I have heard it being used in various contexts, but I don't know what it means. You don't know nothing, do you, Jim? Parmeter, okay. In what context did you hear it used? Rybicki, various media reports related to this investigation. Related to this investigation. Have you ever heard it used with regard to other investigations? No. Okay. What about a sensitive investigative matter? Yes. The term for that is SIM, is that correct? Yes. What about prohibited investigation? I don't think I have heard that term before. Okay. So what does it mean to be a SIM? A SIM is a category of cases that are, yes, category of cases that are designated in the DIOG as being sensitive and require different approvals or extra layers of approvals. Or higher layers of approval? I think higher is fair, or perhaps certain techniques could or couldn't be used in those cases. Certain investigative techniques, such as what? I can't think of them off the top of my head, but certain techniques may not be able to be utilized. Redacted. Okay? You just mentioned DIOG. Can you explain what that is? Certainly. The DIOG is the guide that governs investigations for FBI employees. So this investigation would have been governed by the DIOG as well. I don't know. Do you know whether it governs all investigations at the FBI? I believe the DIOG is supposed to govern all investigations. Breitenbach. Okay, thank you. I'm so sorry. I just mixed a bunch of Breitenbachs in there instead of Parmeters. Breitenbach is the one who brought up DIOG that Rybicki answered about governing all the investigations. And Breitenbach continued that questioning up until Rybicki's answer that the DIOG is supposed to govern all investigations. Breitenbach signs off, okay, thank you, and then Parmeter takes over. My deepest apologies for missing that. Parmeter, so do you know whether was the Clinton email investigation designated as a headquarters special? I guess you had heard that term being used with this, Rybicki. Yes. Interrupts. Parmeter, in this context, who makes that determination about whether something is a quote-unquote headquarters special? Again, I don't know that term specifically, and so I'm not certain it is a term of art for the FBI, at least not one that I am aware of, that I was aware of. And so in what context did you hear that term being used with respect to this investigation? Again, in the news media reports about the investigation as it being, termed a headquarters special. Okay? So who made the determination that the Clinton investigation would be a SIM? I don't know. Who normally determines whether an investigation would be a SIM? Yeah, I think we've already gone over that field there, Parmeter. Rybicki, I don't know. I don't know if it is up to a particular individual or if the DIOG designates it. Do you know when it was determined to be a SIM? I do not. I don't know if it was. Is it fair to say usually, and not with respect to this investigation, is something where a judge to be a SIM, or that would happen at the beginning of the investigation? I don't know the answer to that. To your knowledge, was there any effort or discussion or assertion by anyone, whether at FBI or Main Justice, that this investigation should be run as just a regular investigation and not necessarily a special investigation? Rybicki, can you just repeat that one more time, just to make sure, Parmeter? So I guess what I'm trying to understand is whether or not during the discussions with the director that you were privy to, you had ever heard anyone talking about, the need to not have this be a SIM because of restrictions on investigative techniques, and it should be run as a regular investigation. Oh, no. Okay. Or for any other reason, it should be run as a regular investigation. No, not that I recall. Okay? When did the FBI publicly confirm publicly, it says here, that it had opened an investigation? I do not recall. I believe the ICIG, the Intelligence Community Inspector General's referral, was public. That's my recollection. I don't recall the date. I know there were discussions about whether to disclose the fact of the investigation, but I don't recall a date. In your experience, is it typical that the FBI confirms or denies the existence of an investigation? Typically, the FBI does not confirm or deny the existence of an investigation, except in certain instances. In what instances? There are, excuse me, that came out fast. There are, I guess, a variety of factors, including, public safety, public interests, things of that nature. And who makes that judgment on public safety or public interest? I don't know in all cases. Okay, when you mentioned discussions about whether to confirm that there was an investigation, who was involved in those discussions? So I know in the one instance I'm thinking of, the director discussed with, or the FBI discussed with the Department of Justice, due to Hill appearances, I believe, that were going to happen, whether to acknowledge the investigation of asked. There might have been other instances. That's what I'm recalling, though. And in that instance, who at the DOJ did? And you said the director, but I think then you said the FBI. So was it the director that had the discussions? It was a meeting with the director and the attorney general. Okay, and was anyone else at that meeting? Yes. Okay, who else was in that meeting? I was there. I can't recall all of the participants, so I don't want to speculate, but I know certainly the director and the attorney general myself. And the attorney general myself. There were representatives from, I believe, the AG's office and the deputy attorney general's office, but again, I'm not recalling the individuals as I sit here. I know that at least one representative of the National Security Division at DOJ was present. Okay, and you said Attorney General. At the time, the Attorney General was Loretta Lynch. Thank you. Breitenbach. Who from... Rybicki interrupts. The individual I'm talking was George Toscas. I don't know if he was the only one, but I remember him being there. And George Toscas is second on the list after John Giacolone. I don't see an accent ever on the end of his name, so I'm just going to say Giacolone. If any of you know that it is actually pronounced Giacolone, please let me know in the chat or in the discussion box after this post. I don't like mispronouncing people's last names if I can help it. So I've yet to see anything in video where his name is said out loud. And I still got to look some more, I guess. We'll see what we can find. But anyway, he's up after Toscas is after Giacolone, who is on Wednesday. So Toscas should be this Thursday. Again, unless the IG report drops and then everything gets pushed back while I finish the IG report on the FISA abuses. The alleged FISA abuses. Let's be totally fair. Okay, Parmeter. Okay, so speaking of DOJ, and in particular NSD, what was the role of Mr. Toscas? And we also understand Mr. Loffman, David Loffman, with respect to the investigation. What was their role? Sure. My understanding is that Mr. Toscas is the Deputy Assistant Attorney General over counterterrorism and counterespionage at the National Security Division, and Mr. Loffman is the head of the counterespionage section, so they were supervisors over the prosecutors who were working the case. Okay, and as the Deputy AG was Mr. Toscas, Mr. Loffman's supervisor, as far as you're aware. I believe he is. Okay. Were there other DOJ line attorneys involved in the investigation, like whether either lower-level trial attorneys at Main Justice or AUSAs from the field? That's my understanding, yes. Were there others involved? Do you know who those people were? I don't remember their names as I sit here. I know there were two who briefed the Attorney General at the end, and I'm just not recalling the names right off the top of my head here, and I don't know if they were the only ones. Were they line attorneys from NSD? Were they AUSAs? I believe they were line attorneys from NSD. You said they briefed the Attorney General at the end. At the end of what? Correct. I forget. Wow. Let's try this again. I forget the exact date. I believe it was July 6th when the Attorney General convened a meeting to decide whether to pursue charges. They briefed the Attorney General. July 6th was the day after Comey said he wasn't going to recommend charges, or he wasn't going to pursue charges. One of those two. I don't even remember which it was now, but I do remember that it basically usurped the Department of Justice's role in determining whether or not to pursue a case. So either of those two would have happened. I find it interesting that the AG would have held a meeting to decide whether to pursue charges after what Comey had said. I thought they just got that meeting together for damage control. Maybe I'm wrong. That's how I understood it. And then I'm going basically from the IG report from last year about mid-year exam, which I read on Hat's Guerrilla News. I believe there's a link to it in this channel, in the main channel. Parmeter. So let's talk about, investigative techniques a little bit. In the discussions with the director that were happening monthly and weekly, redacted, and then redacted. I can't recall specifics. I know there were discussions about whether, I'm thinking of one instance, whether to seek legal process for two specific items. I'm recalling that. So, was it for the laptops? It was for the laptops. Whose laptops? Two attorneys related to the case. Parmeter. Redacted, redacted, redacted. Mr. Schools. Redacted, 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 redacted. Wow. This is the most redactions I've seen in one of these, I think, ever. This is interesting. Parmeter. Okay. Well, let's talk about other investigative matters. Did you, to your knowledge, did the FBI execute any search warrants? Ms. Redacted, who is counsel for Rybicki. Do you know? We would object to that. Can I confer with my client? Parmeter. We can go off the record. There's a discussion. Rybicki, thank you. Parmeter. So the question was, redacted. Can you repeat the question? Parmeter. The question was whether or not the FBI executed any search warrants to your knowledge. Rybicki, I am not sure. I am not sure the answer of that sitting here. Okay. Did the FBI conduct any electronic or physical surveillance in the matter? Redacted. Ms. Redacted. Can I confer with my client on that, please? Ms. J. Appel. Of course, let's go off the record. Mr. Rybicki, thank you. Mr. Parmeter. Okay, so we're back on the record. So the question was whether or not the Bureau conducted any electronic or physical surveillance to your knowledge. Rybicki, I don't recall to my knowledge. Man. Parmeter. Okay, so other than interviews then, did the FBI conduct interviews? Yes. Of how many people? Do you recall? I don't recall. Okay. Are you aware of any other investigative techniques other than interviews being used in this case? Yes. What other investigative techniques were used? I'm sorry? To your knowledge, let's preface this all with your knowledge. Rybicki, to my knowledge, I don't know the actual techniques because I wasn't sort of in that level of detail, but I know there were forensic examinations of various sort of electronic devices. Excuse me. Okay, such as laptops and other devices. Is it normal to your knowledge, for an investigation like this to not use legal process or any other investigative techniques beyond the ones you just described? I couldn't answer that in the abstract, partly because of my position. I'm not involved in that level of detail in the investigations. Okay. Sorry, I added that. Parmeter did not say okay that time. Parmeter. So let's talk about the things you were privy to then. Were there disagreements that you're aware of during the weekly updates, the monthly updates with the director, and disagreements internal to the FBI or with the Justice Department over what investigative techniques to use? Rybicki, yes. Okay, and what were those disagreements to the extent that you were made aware of them during the meetings? Sure. One that I'm recalling was the one instance that I'm recalling is whether to seek access to laptops belonging to the attorneys. Okay, and what was the nature of the disagreement? It was a disagreement between the investigative team and what will call the prosecution team over whether to seek access to the laptops at all or how to seek access to the laptops. Whether to seek access at all. Oh, wow. Ho, ho. There's a bombshell. Excuse me for interrupting, Mr. Pometer. That's the first that I had heard that there had been any kind of discussion about maybe not even going after those laptops. That is huge. To say that the DOJ was talking about not allowing anyone to go after the information on those two laptops, which were full of Clinton emails. I find that amazing. Absolutely amazing. Wow. Let's see where we go from this. Okay, Rybicki, whether to seek access at all, referring to the laptops. Parmeter, okay. There we go. And what was the nature of the disagreement? You know, who was advocating for seeking access to the laptops and who was not? Rybicki, may I consult 1 second? Sure. Rybicki, thank you. Parmeter, you're welcome. So I guess the question was, you know, who was advocating for seeking the laptops and who was advocating for not seeking the laptops? Sure. I don't know the specific individual, but what I will call the investigative team, so the FBI side was advocating to get access to the laptops. And the Department of Justice, and again, I don't know the level, did not want access to those laptops or did not want to authorize access to those laptops. You don't know the level, but you do know the entity at the DOJ? I don't. That might have been discussed in these updates. Just sitting here, I don't recall. Okay? Summers. What did you mean by authorize? You said they didn't want to authorize. Rybicki, didn't want to authorize any access to it. Authorize whom? The FBI? Rybicki, the FBI. Authorize them for the laptops? Authorize them to ask for the laptops. Rybicki, so I just want to be precise because I don't know whether they sought by consent first. I just don't recall that level, so I want to be careful if that's what you're asking. Summers, that's what I'm getting at. Rybicki, so process versus content. I don't recall that sitting here. So did the DOJ attorneys, they didn't want to authorize a search warrant or other compulsory? Rybicki, again, just to be careful, only because my recollection, I can't remember whether the Bureau sought consent first and then were seeking, if they were denied consent access to sort of compulsory process. I just don't have that level of recollection on it. If you'd followed the news, you'd know. I'm sure that, excuse me, that was me. I'm sure that was discussed in these updates just sitting here. I don't remember. And you also don't remember, are we talking National Security Division or U.S. attorneys? Yes, I would be speculating. I don't know. And the investigative team, you referred to investigative team. Is that just FBI or are there prosecutors on the investigative team? So I'm just using that term just to talk about FBI here. I mean, they certainly work jointly with Summers. I mean, what were you referring to? Yes, I was referring here to just FBI. Thank you. Yes, certainly. But ultimately, the FBI did gain access to the laptops in question, right? That's my recollection. And do you remember how access was gained? I believe so, but I'm not certain. Again, that's a level of, I believe I recall hearing about the resolution of it, but that's a level of detail that I don't think I was involved with. Okay, let's back up briefly to, one of the investigative techniques that the FBI relied on, you said, was interviews, correct? Excuse me. You didn't recall how many people were interviewed, but you do remember who was interviewed. Can you remember people that were interviewed by the Bureau in this case? I probably could, especially if I was prompted, but I don't think I would have the universe of knowledge on that. So you didn't remember how many people. Do you remember about how many people? I don't. I would be speculating. Okay. Even if you were prompted, was it 24 people? Was it more? I believe it was more, but again, I would be speculating. It is just not a level that I would be, even if updates were being given, it is not something that would be for my role, that would be, need to be interested in. Parmeter. Were there discussions at the regular meetings with the director about the interviews that had been conducted and were going to be conducted? Reading too fast here. Rybicki. Yes, that's my recollection. Parmeter. And during those meetings, the agents didn't say we have now interviewed this many people. They would just talk about interviews that had been conducted. I'm certain they probably gave numbers and things like that, but again, that is not something that I'm remembering here or, would have considered important to me at the time. You were in the meeting with the director when he was told by Attorney General Lynch to call the Clinton email investigation a matter. Is that correct? That's correct. When did this meeting occur? My recollection is fall of 2015. I don't remember the exact date. I do remember that both the director and Attorney General Lynch had Hill appearances coming up, and that's what prompted the meeting. By Hill appearances, you mean testimony before congressional committees? That's my recollection, yes. And where did the meeting occur? At the Department of Justice Command Center. Okay. Who else was present at that meeting? Again, I don't remember all the folks. Certainly the director and the Attorney General Lynch. Again, my recollection is that the AG's office and Deputy Attorney General's office staff were there. I don't recall whether the Deputy Attorney General was present. I was present. I don't recall who else from the FBI was present. It is likely the Deputy Director was there. Again, I just don't recall at this time. Because I'm trying to save the butts of people I work with, and it's not going to work, says me. So is this the same meeting? This is Breitenbach asking this question, so let me back up. Breitenbach, is this a different meeting from the one you previously described where you were discussing whether to disclose the investigation, or is this the same meeting? Rybicki, I was thinking of it as the same meeting. Parmeter, so that is the same meeting where you discussed whether to disclose the existence of an investigation and then the matter. Rybicki, yes. Again, I think it is likely that, there are other discussions about whether to disclose that. This is the one I'm remembering, though, and especially because my recollection is that we thought both of these may be asked about, and, how would we respond? How would they respond? So did the Attorney General direct the director to call it a matter because of the congressional testimony, or in connection with his congressional testimony, or just generally speaking? Rybicki, I would say just generally speaking. Yes, I don't recall the specific words used, but I would say just generally. Okay, and how did the director react to that directive? Sure. I think in the meeting, I don't recall his reaction. I remember discussing it. Excuse me. It takes a while for my voice to warm up in the morning. Let's see. This is Rybicki still. I remember discussing afterwards with him, and I don't know if that was one-to-one, one-on-one, or with others at the FBI. Just that would be, given what had been disclosed already about it, that would be a very hard line to hold. Parmeter, and do you recall saying anything specific to him about the characterization, of the investigation as a matter following that meeting, and whether or not you should push back against the Attorney General's directive? I don't recall. Do you recall anyone else saying anything to him about that? I don't recall. Again, I remember having discussions about it, and, again, most likely with others in the FBI. I just don't recall if there were discussions about whether to push back or not. In your experience as Chief of Staff, I imagine you have witnessed a lot of investigations proceed from the FBI. Are you aware of any other instances where the Attorney General or anyone else from DOJ directed the FBI to refer to an investigation as anything other than an investigation? I'm not. Okay? Do you know what the other DOJ's personnel's opinion of the Attorney General's directive was, particularly someone like George Toscas? Certainly. I remember a sort of quip that he said after the meeting that could indicate what he thought of it. What was the quip? It was basically, and I don't know if this is verbatim, but it was basically, I guess you're the Federal Bureau of Matters now. I remember that one, and I knew it was coming as soon as I saw that where he said, I remember sort of a quip. I knew it was coming, but I could not hold back the laugh. It's that is such a biting, biting indictment of what Lynch just did to Comey. Oh, man. Very witty. Very witty. Summers. How is this sort of passed on? You go to the meeting with the Attorney General. She directs the investigation to be called a matter. Certainly not everyone involved in the investigation was in that meeting, you know. What was the report out of that meeting? Were the investigators told to call it a matter? I mean, how did that trickle out? I don't know the answer to that. I don't know whether it was communicated or not to the investigative team. Dude, how could it not have been? Seriously. Okay, they went off the record for a break. They come back at 11:15. We're now 5 minutes uh, in the bank here, so we lost a little time, but not much. Summers. And was it, in fact, called a matter? I don't recall as I sit here. I remember as part of those discussions that it was mentioned to Mr. Parmenter, with the director, discussing, even if you were to say matter, that's not a distinction that I think would be meaningful to people. And again, I don't remember his specific words, but I do remember, I believe, reading sort of reporting after these appearances where it basically said investigation, instead of matter. Summers, and do you recall you mentioned George Toscas's reaction to the matter versus investigation? Do you recall anyone else's reaction? That's the only one that stood out to me. Other than Attorney General Lynch and other FBI employees, did the director, to your knowledge, discuss the Clinton matter with any other administration officials? I'm sorry, I just want to make sure. Parmenter, by this I mean By this I mean anyone outside of obviously outside of the Bureau, sure. Outside of DOJ, yeah. Anyone else? Rybicki, as I'm sitting here right now, I mean, I would want to think about that carefully. I don't recall as I'm answering right now, but I would want to give it a minute if we wanted to revisit it. Do you ever recall him discussing it with the president? No. Do you recall him discussing it with the White House? No. Let's get back to what you said about publicly disclosing the investigation. I believe you said that in certain circumstances involving public safety or the public interest. So I assume in this case, the consideration was of the public interest. Is that correct? I think that's right. I think the primary goal, and if I may, as the director articulated it, there were basically three main concerns that he had, all surrounding the integrity of the investigation. Okay, so do you recall specific discussions with the director about the need to confirm that the investigation was ongoing? I know we talked about the meeting at DOJ, but, as generally speaking, the FBI doesn't confirm or deny any existing investigations. So do you recall ongoing discussions about the need to confirm the matter? Excuse me. This is the green tea with mint. I'd been out of it. Much better. Much better for me. My excuse me. Let me go back to Parmenter here. Last sentence. So do you recall ongoing discussions about the need to confirm the matter? Rybicki. My recollection is that there were discussions because of sort of what had been out there in the public already. Again, I think my recollection is that the Inspector General's referral was public comments by Secretary Clinton herself, and so I know that was all being weighed in the context of would it be disingenuous for the Bureau to either no comment or give the standard response if all of that information was already out there. Okay? But, I mean, even in normal cases where, the press is reporting about, something the FBI is allegedly doing, does the Bureau generally confirm or deny even things that are reported in the press? I would say generally, no. Okay, so how many discussions do you recall with Director Comey about sort of the process by which you all decided to publicly confirm the investigation? I don't recall. Who ultimately made the decision to publicly confirm the investigation? I don't remember a decision point. I would have to say the Director Comey. During those meetings that we talked about already, the briefing meetings, did Director Comey ever suggest any particular individual be interviewed? I don't recall sitting here. Let me change positions for a second. sit up for a little bit. Keep my spine from collapsing. Move that. There we go. Let's see, I don't recall sitting here. Okay, this is Parmenter. Do you recall specifically if he said, we need to interview Uma Abedin, we need to interview Cheryl Mills, or any of the other people that were, high-ranking officials at the State Department or anything else? Sure, I don't recall. Okay. Did anyone express any caution about interviewing certain high-ranking officials? I don't recall in-depth discussions on that. Just sitting here, I'm not saying it didn't occur. I don't recall either way on that one. Do you recall anyone discouraging the investigators or others from interviewing any particular individual? No. No prohibitions on interviewing anyone that you're aware of, not that I can recall. So, on the subject of those ongoing meetings, is that a normal occurrence for, a typical investigation for a SIM or for any other investigation to have a regular update meeting for the director? No. Okay, so I'm interested in a little more about your role at those meetings. Was your role just simply to support the director, or did you have some other role? I would say that's a fair characterization, to support the director, and I was frequently in and out during the meeting, handling other matters, things like that. But yeah, primarily to support the director. I would characterize the participants as sort of the folks who were briefed on the investigation and involved in the investigation, and then the executives, and then the lawyers. Summers. When you say characterized, I've read your OSC testimony. Is that what you're referring to, the mid-year exam team and the executive team? I think that's how you refer to them in that interview. Yeah, there was a lot of confusion in that. That was Mr. Summers, by the way. I missed that. That's when he first came in. So Summers asked about characterizing the team and the executive team. Rybicki, yeah, there was a lot of confusion in that interview, so I was trying to help them understand the difference between the team that was providing the updates. And so I think those are the ones I'm referring to. When I talked to Mr. Parmenter about the updates for the director, that's what I was referring to in the OSC transcript as the executive team, just for ease, and then the investigative team that I was thinking of the people, the others who were doing in the FBI, the agents, analysts, and others doing in the actual investigation. Summers. And that's the mid-year exam team. I think that's how you referred to it. Or refer to it how you refer to it, but something along those lines. If I'm recalling correctly in that transcript, I was referring to the mid-year executive team at that briefing team, and then the investigative team as the others. Excuse me. Summers. Mid-year review team, mid-year exam team, that's the investigative team. That would be the investigative team. Yeah, it got a little confusing in that transcript, so I was trying to help them understand how it worked. Summers. And then when you say the investigative team, we discussed that a little bit earlier. Is that mid-year exam investigative team? Is that all FBI, or is that broader? When I'm using it to mean the FBI. Summers. And that also goes for your OSC interview. Right. Summers. Okay. Parmenter. So that's the first hour. I guess we'll take a short break, and then we'll turn it over to our minority counterparts. Rybicki, thank you. So they take a recess, a 10-minute recess, and they come back on at 11:35. So now we've got a 17-minute buffer, so things are moving along nicely. And again, this is a 240-page report. We're going to read right around 120. I'll try to find a natural point of break. Usually that occurs when one side of the aisle turns over to the other side, questioning. So we'll try to find that. Or there might be a recess, something like that. But we'll figure it out when we get there. Excuse me. Okay, Saxman Grooms. This woman can be excruciating when she does her questioning. First of all, most of her stuff is actually just rebuilding the reputations of the witnesses and the FBI. In this particular instance, though, she's also interested in throwing Comey as far under the bus as possible, because Um, well, I'm going to have to take that back. Um, no. Still, I was thinking that because Comey had been fired by this time, that she was going to try and rehabilitate Comey as well. But Comey's responsible for mid-year exam debacles, the July 5th um, press conference, and then the late October release of the information that they had reopened the investigation into Clinton because of the emails found on Anthony Weiner's laptop during an unrelated search. Um, that came about both under Comey's watch, and the Democrats hate him for that. Um, so the last transcript we did, she was ripping into Comey left and right. So now that I think about it, I should expect her to continue to do that. Let's see what happens, though. So rehabilitate the witness, rehabilitate the FBI, probably rehabilitate the DOJ as well, and Loretta Lynch, and then rip apart Comey. So she's going to be a busy girl. Lady. Ms. Saxon-Grooms, lady. Sorry. Just reintroducing ourselves. My name is Suzanne Saxon-Grooms, and this is Aaron Hiller, Representative Krishnamurthy, and Representative Plaskett. Mr. Krishnamurthy is going to start us off, and it is 11:35. Krishnamurthy, good morning. Thank you. Good morning. Good morning. Thank you so much for coming here on short notice, Mr. Rybicki. I'd like to ask you a few questions about your background to start off with. First of all, can you start with your educational background, starting with college? So here we go. We're rehabilitating the witness. Rybicki, certainly. I received my bachelor's degree from the George Washington University in Washington, D.C., and I received my law degree from the Catholic University of America evening program. Krishnamurthy, very good. What were you doing during the day? I was working at the Department of Justice. And what were you doing at the DOJ? At the time when I started law school in 2004, I was in the office of the Deputy Attorney General and then was in the Eastern District of Virginia when I finished. Very good. Did you also attend the Federal Law Enforcement Training Center? I did. And what did you receive upon graduation from that? Certainly. I was a federal police officer with the United States Capitol Police. I went through the Federal Law Enforcement Training Center with I believe it was called the Mixed Basic Police Training Program. Very good. Well, obviously, we appreciate your service as a Capitol Police officer. What certifications do you have? I have a member of the bar in New Jersey and the District of Columbia. Very good. Why did you make the career choice about entering the Capitol Police? I worked for the Judiciary Committee, actually right after college, interned, and then worked for the Judiciary Committee. I went with the Capitol Police because of the quality of the agency and because I wanted to be a special agent with the Federal Bureau of Investigation. And so I entered with the Capitol Police, but then had the opportunity to work for the Department of Justice. Unfortunately, shortly after I went through the academy and was on the job for a while. Was that with the House Judiciary Committee? It was with the House Judiciary Committee, the Crime Subcommittee. Mr. McCollum was the chairman at the time. Very good. Excuse me. Very good. Now, you made the decision to join the Department of Justice in 2001. Why did you make that decision? Again, I've always wanted to work for the FBI. My boss from the Hill became an assistant attorney general for legislative affairs and offered me the opportunity to come work with him. In more than 15 years of your service with the DOJ, you served in numerous capacities in different offices. I'd like to ask you about just a few of your many appointments. Rehabilitating the witness, as I said. First of all, you worked at the Office of Intelligence, Policy, and Review. What did that office do? Sure, Congressman, that was the predecessor to the current Office of Intelligence, OIPR at the time, processed all of the FISAs for the department. And what did you do at that office? Sure. My role, I had just come from the Office of Legislative Affairs, and they hired me into OIPR, Office of Intelligence, Policy, and Review, to handle their semi-annual reporting requirements on FISA to the Congress. So my job was to process those reports and keep the files up to date in order to report to Congress. As well as some other duties, I was a non-attorney at the time. By the way, you joined after September 11th? I joined approximately 2 weeks before September 11th. Okay, so you were very busy after you joined. Yeah, very new and very busy. Yeah. You served in the office of the Deputy Attorney General during the George W. Bush administration. What work did you do in that office? Certainly. I was detailed to that, a temporary duty assignment from the OIPR that we just spoke about to the office from the OIPR that we just spoke about to the Office of the Deputy Attorney General to work on basically special projects for the Deputy Attorney General, working very closely with his Chief of Staff. Excuse me. Who was with the Deputy Attorney General at that time? Jim Comey. Jim Comey. Okay. In your last appointment before joining the FBI, you served in a leadership role in the Justice Department's National Security Division. Could you tell us a little bit about what the National Security Division does? Certainly, Congressman. So after I graduated from law school, I was then hired on as an honors attorney with the department and came back with the Office of Intelligence, which was part of the National Security Division. The National Security Division was formed a few years after 9/11 to centralize the national security functions of the department, not including the FBI. So the counterterrorism and counterespionage sections from the criminal division were part of that, and they handled the prosecution side of the house. And then the OIPR, the office we spoke about before, became the Office of Intelligence, and they handled the FISA work for the Foreign Intelligence Sovereign Immunity Act, work for the department as well as oversight of that process. When you look at it, we've been saying FISA, FISA, FISA over and over again for years. But look at the actual title of it, Foreign Intelligence Sovereign Immunity Act. Sovereign Immunity Act. See, a sovereign immunity to me means that you are providing immunity to a sovereign entity, when in fact, this is just the opposite. You are stripping immunity from a sovereign entity. Maybe I'm just reading it wrong, but that's how it strikes me. And I usually have a pretty good flair for context. That's one of my watchwords is context. Ask my executive producer. So, I could be wrong. It's just how it strikes me. Okay, back to the questioning. Mr. Krishnamurthy. Okay, I understand. So just to put this in chronological order, you were at the DOJ, and then you went to law school at night for a few years between 2001 and 2004, and then went to the National Security Division? Sure. The law school was 2004 to 2008. Oh, I'm sorry. Yeah, that's okay. And then with the National Security Division right after that. I understand. Now, when did you join the FBI? I initially started as a detailee to the FBI in November of 2013. Why did you join the FBI? I had the opportunity, so a mentor of mine, Chuck Rosenberg, became the Chief of Staff to the Director of the FBI, and he offered me the opportunity to come over as his deputy. Now what is your current title at the FBI? Chief of Staff and Senior Counselor to the Director. Okay, and what does the Chief of Staff do? General duties are to support the Director of the FBI and to supervise the Office of the Director. Okay, and when did you become Chief of Staff? May of 2015. May of 2015. So that would be for former Director Comey. Correct, Congressman. And you continue to serve in the current role under Director Wray. Not for long, if I may add. Rybicki, that's correct. I served, so Director Comey, and then I served for Acting Director McCabe in that summertime period, and Director Wray asked me to stay on for him. Just for a second. Move the keyboard over a little bit here. When did, oops, there's an I and D, did. When did James Rybicki quit the FBI? Okay, here we go. where's the date on this? Oh, here we go. January 23rd, 2018. So that's fascinating because this interview happened on the 18th of January. So this isn't even a week later, and he bounced. Wow. I wonder if all those do not recalls caught up with him faster than he expected. But anyway, that shows you how long Rybicki lasted after this interview. Not even 7 days. Okay. Go back to Rybicki's last statement. I served, so Director Comey, and then I served for Acting Director McCabe in that summertime period, and Director Ray asked me to stay on for him. And how big is that office? How many employees are in that office? The office proper has redacted that directly support the director. The office of the director, as it's defined by the Bureau, also encompasses various other offices in the Bureau, like the Office of Public Affairs, Congressional Affairs, and so forth. So on paper it looks quite large. There's about redacted or so folks in our direct sort of chain, and then in the, reporting to me, about 5 or 6 folks directly. Krishnamurthy. Okay. So you have a lot of administrative responsibilities as part of your current role, right? Correct. Okay. Yeah, who is he? Is he Parmeter? Now, in your long and distinguished career at the DOJ and FBI, have you ever let your personal political views, whatever they may be, influence in any way your official actions? No, sir. Well, there's not a softball and leading question by any stretch of the imagination. Can't imagine Rybicki would have given any other answer than no, sir. But, maybe... No, not at all. Not at all. And again, this is rehabilitation. And that's partially now rehabilitating the witness and the FBI at the same time. And DOJ, as I said, because he mentioned both of those in the question. Okay, Krishnamurthy. In your career at the DOJ and the FBI, have you ever witnessed any law enforcement personnel letting their personal political views influence in any way their official actions? No, sir. What kind of structures and processes are in place at the FBI to ensure that the decision to recommend prosecution or to not recommend prosecution of an individual cannot be based on their personal political bias? Congressman, I don't know if I can articulate all of them because I'm not in what I would call the operational side of the House. I alluded earlier to the most FBI employees. In fact, there are 2 direct reports to the director, myself, and the deputy director of the FBI. The majority of FBI employees report up through the deputy director, what I'll call the operational side of the House. So almost the entirety of it. So any investigation would fall under the deputy director. And so I only bring that up because, I don't have any direct supervision of the investigations and operations, just for clarity. But going to your question of sort of what processes may be in place, the DIOG, which I referenced earlier, is the guide that governs FBI investigations, and in there are various processes that, for guiding the FBI investigations, including various approvals, various consultations, for instance, with the Office of the General Counsel and others. And if there's any detection of any political bias in an investigation, what are you instructed to do? I don't know the answer to that, Congressman. I know we have a robust inspection division that operates within the FBI. That inspection division conducts oversight and investigation, and they work very closely with our Office of Professional Responsibility and also with the Department of Justice's Office of the Inspector General. I see. And that office of, you called it Inspection Division? The Inspection Division. I see. And that is relatively independent within the FBI? Yes. I mean, it falls under the chain of command, but they do what they call inspections of offices, and then they also investigate allegations of misconduct. I see. What is your reaction to recent charges of political bias that may have been leveled at the FBI's leadership with regard to the handling of the Clinton investigation? My personal reaction is one of sadness. because I respect the institution immensely. And so anything that would undermine the credibility of in such a critical institution, our nation, for our nation, saddens me. Yeah, James, well, if that's a fact, then why was everyone at the top of the FBI and DOJ crooks? Maybe they wouldn't be under such critical scrutiny if you guys hadn't run completely either fallacious investigations into purely criminal acts by Hillary Clinton, and then a completely facile and transparently political investigation into the Trump campaign for supposed ties to Russia, none of which were ever found, even 7 months after the FBI started it during Crossfire Hurricane, much less before the Mueller probe got into it and still didn't find anything. Now, in regards to the Mueller probe, if you look on my Hats Gorilla channel, there's a video, and I'll try to link it. Let me see if I can make a note here. Link. Let me see. Mueller, Russia indictments. Okay. Yes. When Mueller released the press report about the Russians that he had indicted, the ones from the Internet Research Agency and the ones that were here in the U.S., or at least posing as U.S. citizens, creating Facebook ads for different presidential candidates. Remember, those ads were for both Trump and Hillary, against Trump and Hillary, and against Bernie. None of those ads, I shouldn't say none of the entirety of those ads, were directly against Trump or directly against Clinton or directly for Trump. That is a narrative, and that is a lie. Also, many of those ads did not appear until after the election. So there's another subset of lies. Some of them were slightly effective, but none of them have been proven to change anyone's vote. None of them. In fact, those ads came in, if I remember correctly, fairly late in the election, at least the bulk of them. Thereby, most people have already made up their minds and are going to be looking for things that reinforce their views as opposed to change their views. So there's that. Anyway, when Mueller announced those indictments, there was not one mention of anyone in the Trump campaign being involved with any of that, including Roger Stone. So, the main point of my video was not to read the Mueller report or the Mueller press conference without any commentary. My commentary was, this proves that Trump did not collude with the Russians. This ends the collusion report for the Mueller team. And there's no reason it shouldn't have. But it dragged on and on and on. So I think Mueller needs to come in front of Congress and answer some tough questions about why the collusion investigation continued after that point, and what he thought he was doing, when in fact he should have said, I didn't find any collusion with the Trump campaign, I didn't find any collusion with Trump, or coordination, whatever you want to use, collusion or coordination, or both. I didn't find any of that. Therefore, this investigation is going to come to an end. Instead, he let it run for another year, trying to trip up Trump into making him commit an act of obstruction against Mueller, against the Mueller office, so he could ring him up on a criminal charge. And he failed to do that. He tried to imply that he could have, but when you read the Mueller report, like we did here, especially Volume 2, you know they had nothing. There was no smoking gun about obstruction, not much less any actual hard evidence of criminal intent, which is what you need. Mueller tried to shade it that way, but it was never there. So that's what you got there. All right, it's enough editorializing for now. Let's get back to our story. So Rybicki's talking about being sad about charges of political bias being leveled against the FBI, which shouldn't be. It shouldn't be sad. It should be introspection, James. Anyway, Krishnamurthy, Mr. Rybicki, I want to kind of leave this as a. I'm not sure what that meant, but I want to thank you again for your distinguished service. I want to leave you with kind of our sentiment that, you and your team have been critical to kind of the safety and well-being of our nation, and I want to thank you for your, distinguished work over the last 2 decades. And I believe our nation is safer because of your work. Thank you. Thanks, Congressman. Rybicki also adds, thanks for the flag, so now I can wrap myself up in it and be impervious to any other questions from the Republicans, because that's what you're doing for me. Maybe I said that. I'm not sure. Okay, now, Ms. Plaskett comes in. I've never heard of Ms. Plaskett before in any of these, so this ought to be interesting. Good morning still. How are you? Rybicki, good morning. Well, thank you. How are you? Plaskett, good. And thank you for the work you've been doing thus far. You and I have had some overlap at the Justice Department. Chuck was a colleague of mine, as well, us both having worked for, well, at the time, he was the DAG, Deputy Attorney General Comey. And Chris Wray is not only someone who I respect greatly as a former supervisor of mine, but as an individual. Okay, so what are you doing on this panel? Shouldn't you be recusing yourself for conflict? I mean, maybe that's not a thing on these panels, but possibly it should be. So she continues. And I want to thank you as well, and, for someone who, I also went to law school at night while working during the day, I think that makes us much more focused attorneys than others would be. We use our time maybe a little more wisely. Don't attend as many after-school functions, shall we say, as everyone else, right? It can be kind of hard to when you're in school. Back to Plaskett. I've been troubled by the recent attacks against the Department of Justice, both personally as someone who holds in the highest esteem the fact that I worked there in Main Justice and the FBI, which reports to the Department of Justice, and the attacks about the independence of the institution as a whole and the integrity of the employees. I just wanted to ask you briefly a comment you just made when the congressman asked you about statements that were made with regard to the investigation of Hillary Clinton, Secretary Clinton, at the time. And you said that they saddened you. What I wasn't clear of was it the conduct of the investigation that saddened you, or was it the statements about the investigation that saddened you? Rybicki, I think it's right. I want to thank you for the opportunity to clarify that if I left a misimpression. I think my comments were directed at sort of attacks on the institution. I think you can agree or disagree with the decisions that were made. But what I think is very important is to know that they were done in a proper way. Ha! So attacks that they, were based on improper decisions or influence, I think, is what saddens me. Plaskett, got you. Rybicki. But I think there's certainly room for oversight and for, legitimate asking questions about why decisions were made. Hence our being here this morning, correct? Yes. So, on December 3rd of 2017, President Trump tweeted, here we go with the tweets. This is another favorite tactic of the Democrats, is to use Trump tweets as a basis for impugning the entire process against the FBI for completely submarining the Clinton investigation, the mid-year exam investigation. And I should put the DOJ in there as well. Because as we've seen on a couple of occasions here, the FBI did push back against the DOJ. It was the DOJ who was telling them to basically run the investigation into the ground and then find Clinton not chargeable. That was their directive from pretty much the outset. Had to have been, because it was obvious that Clinton had in fact violated the law in several different ways during her time as Secretary of State. So the DOJ had to clamp down on that. But so this is a tweet, a true tweet nonetheless, but Plaskett won't see it that way. Quote, after years of Comey, with the phony and dishonest Clinton investigation and more, running the FBI and its reputation in tatters, worst in history, but fear not, we will bring it back to greatness. Close quote. Do you agree with the president's statement that the FBI's reputation is in tatters and worst in history at that time on December 3rd of 2017? I prefer not to comment directly on the statement, but I would like to. I don't believe that the institution is in tatters by any means. In fact, I think the FBI is as strong as it ever was, and the core functions of the FBI continue on no matter who is the director. The people may feel some effects of outside statements that are being made, and that is of concern, but I think the day-to-day work of the Bureau remains as solid as ever. Yeah, especially your complete railroading of George Papadopoulos and shackling him at an airport when he's committed no violent crime whatsoever, and making him walk in chains on his ankles and wrists to a black SUV, and then whisking him off to a holding cell and holding him for 24 hours, basically incommunicado. That's the rank and file FBI there. And again, read George's book. Because it's called A Deep State Target, and it's incredible. In fact, my wife just finished it, and she referred to it as, and I agree completely, a real page turner. You could seriously read it in about, if you just sat down and started and went right through, I think you could read it in about 4.5 or 5. Well, I can read it in 5 hours, but I'm a speed reader. I think anyone, though, if they sat down and put the time into it, could read it in a couple of days. No trouble whatsoever. Absolutely none. It's not overly thick, but the detail and the narrative are very compelling. Very compelling. Read that book. That'll change your mind about the rank and file of the FBI. And so Rybicki finishes, I think the day-to-day work of the Bureau remains as solid as ever. Plaskett, so it would be your concern that statements may impugn the reputation of the FBI, but not the actions of the FBI agents themselves. I'm sorry, Congresswoman, can you repeat that one more time? So it would be your characterization that the statements may impugn the character of the reputation of the FBI, but not the work of the FBI itself, that would cause that reputation to be in question. Oh, what a maroon, to quote Bugs Bunny. Oh my goodness gracious. It's the tweet that hurt the FBI. That tweet came out of left field. There was no reason whatsoever for Trump to make that tweet. There was absolutely no possibility that tweet had any basis in reality. It was just a completely offhanded attack on the FBI made for no reason whatsoever. That's what Plaskett just asked. That it's not what the FBI did that hurt the FBI, it's Trump's tweets that are hurting the FBI. Bravo for the balls to ask that question. Bravo. Let's see. So Rybicki answers, that's correct. I mean, any misconduct or any other allegation, as I mentioned to the congressman, are handled appropriately. But, to your point, the great work, of the people of the FBI continues. Thank you. and the characterization that was made in that statement of the Clinton investigation, how would you characterize the overall conduct of that investigation? I think it was done in a thorough and professional way. Thorough, like the DOJ wouldn't let you have access to 2 laptops that Clinton used and had thousands of emails upon them. Upon them? Seriously. They had thousands of emails on them from Clinton, then many of which were classified until the lawyers were able to delete what they saw as work product or personal emails themselves. Yes, that's what happened to those laptops. The FBI finally said, "Look, we want them," and the lawyer said, "Okay, let's talk about this. We'll make a deal. We'll give them to you, but you've got to let us scrub them of work product and anything unrelated to the investigation." And the DOJ, through the FBI, said, "Okay." And so the lawyers were allowed to delete material at their own discretion, while basically affirming to the FBI DOJ that they weren't deleting anything that could incriminate Clinton. Do you believe that? Do you believe her lawyers would leave incriminating material on those laptops? If you do, you should be the director of the FBI. I think it was done in a thorough and professional way. Plaskett. In what effect, now, there may be external effective statements like that. What effect do you think that has on the morale of the rank and file of the FBI, that the commander-in-chief would make statements of that nature? Knowing that you do not have direct report over those individuals, but sitting in the office that you do, and having a purview over everyone. Sure, I think that's right. I think anything, just as anybody would in any line of work, any time that you're being questioned like that, I think it could have an effect. Okay, thank you. On December 15th of 2017, after the first statement, our president, before boarding Marine One to visit Quantico, made the statement, quote, "Well, it's a shame what's happened with the FBI, but we're going to rebuild the FBI. It'll be bigger and better than ever, but it's very sad when you look at those documents and how they've done what is really, really disgraceful, and you have a lot of very angry people that are seeing it." A completely true and accurate tweet, Plaskett. There's nothing you can say against that without lying. Back to Plaskett. Do you agree with the president that the FBI has done something really, really disgraceful? I don't know the context to which he was referring, but I do not believe so. Meh, he can't even give a definite no to that completely softball leading question. I'm sorry about the microphone, sorry. He can't even say no definitively on something like that. I do not believe so. Wow. Okay, Plaskett continues. Okay, and then it would appear that the president's statements have, in fact, been echoed by a number of my fellow members of Congress. On December 5th, after the first tweet from the president about that, the Oversight Committee Chairman, Mr. Gowdy, tweeted that the Bureau has had a really bad last 18 months. Would you agree that your last 18 months have been really bad? I think it's been a very difficult 18 months. And what has made that difficult? I would say the events and circumstances of the last period. Would one of those events have been the firing of Director Comey? Yes. And looking back, or actually leading up to when you look back to the lead up to Director Comey's dismissal, would you agree or would you say that that created a loss of confidence before his firing, the events that led up to his firing in the rank and file? Like I said, sometimes these people can't ask questions to save their butts. Rybicki, I'm sorry, I didn't. Plaskett, would you say that there was a loss of confidence of the rank and file of the FBI leading up to his firing? Lost confidence in the director? Yes. Rybicki, no. Plaskett, why would you not think so? Based on people I talked to, just, general statements from within the Bureau, my own impression of what people thought of the director. And what were those reactions that people had when he was fired? I think there was sadness. I think there was, Plaskin interrupts, Rybicki, sadness to lose Director Comey personally, but also determination that the work of the Bureau would continue no matter who was leading. Plaskett, who was the director, right? What was your reaction? Did you share in that sadness? I did. I consider Director Comey to be a friend and a mentor, and so, yes, it was sadness. I'm so blue that I'll no longer see you, Director Comey. I'm so blue that you are kicked out onto the street. I hope you'll land on your feet, but until then, I'll be blue for you. The Rybicki Comey Blues, folks. Plaskett, did you find him to be an effective director? I did. And do you believe that the work of the Bureau has continued? Yes. And under Director Wray, there has been a quantum shift in the direction of the Bureau? No. So the Bureau has continued to do the same work that it was doing under Director Comey. Correct. Yeah, but now it's doing it legally. Now it's following the law, Plaskett. Maybe you should ask that question. Rybicki, correct. Would you say that the leadership transition has been smooth? Rybicki, the way I've characterized it is the core work of the FBI, the everyday work protecting the nation and the American people and investigating crimes, has continued unimpeded, despite the director being fired in May. What I would say has been an impact are sort of long-term planning and policy decisions, things of that nature. So that's been an impact, but the very core of what the FBI does has been unimpeded. Krishnamurthy, excuse me, folks. Could you please take your conversations out of the room? Thank you. Bad gallery witnesses. Bad. Sorry, attendees. Shame on you. Good for Krishnamurthy to kick him out. Good for him. I think Goodlatte should have been on top of that. Unless they were behind Krishnamurthy, and therefore they were disrupting him specifically. Just to say. Plaskett, when you say the long-term planning, is that a direct outcome of the firing, the effect that has had on the planning? I think that's accurate. I would say any transition period would have caused that as well, especially one as abrupt. Okay, I have no further questions at the time. Thank you. Thanks, Congresswoman. Saxman Grooms. Here we go. I just want to start by covering a couple of things that went over in the previous hour. The DIOG is the guide that the FBI that basically sets the protocols for investigation. Is that an accurate description? Excuse me just a moment. Hello, Jason. Yes, you did jump into a song. I kind of lost my mind for a moment. You'll have to forgive me. Well, so far we're covering Rybicki, the now disgraced former let's see, what was his exact title again? Chief of Staff to the Director of the FBI, who quit 5 days after this interview, quite unexpectedly, I might add. He has been doing a ton of I don't recalls to direct questions. He doesn't know anything about anything. The only parts he has given a definitive answer to were that, yes, the DOJ told Lynch, specifically told Comey, to call the Hillary Clinton mid-year exam investigation actually a matter, and that George Toscas joked, or quipped is the exact quote, after Lynch left the room was, well, I guess now you're the Federal Bureau of Matters, which I laughed at quite loudly. Had to. Let's see. They weren't able to nail him down on anything to do with decisions on investigative matters, like how to investigate certain things. Although he did talk about that there was friction. In fact, there was out and out disagreement between the DOJ and the FBI over the two laptops that Clinton's lawyers were sitting on. It turned out that the FBI wanted to access them, although he didn't say if they wanted to just do it by consent or by subpoena or other means. And that the DOJ said, we don't want you to go near them. I'm paraphrasing, but that's the gist of what they were saying to the FBI. Leave them alone. We don't want you to touch them. I found that to be fascinating, quite fascinating. Now, as far as the Democrats have been doing, which we've been reading for about the last 40 minutes, the Democrats have been doing the typical rehabilitating the witness, rehabilitating the institutions, and trashing Trump's tweets. How's that for an alliteration? That's basically what's going on right now. We're finishing up the Democrats. I think they've got about another 20 minutes left in their questioning. And then we'll be back to the real questioning with the Republicans. That's basically where we're at. I hope I answered everything. With all that said, oh, by the way, I did start the stream for about 5 minutes with the microphone off. I did it again. So when you go back to listen to the rest of this, make sure that you look for the timestamp either in the title or in the description box that will show you when to start without having to watch a silent movie. I screwed up, but I caught it at least before you showed up, which is my first stream. It took me 45 minutes to notice that I had not turned my microphone on. That's how bad I was. So there we go. Okay. So let's start again with Saxman Groom's first question. I just want to start by covering a couple of things that went over in the previous hour. The DAOG is the guide that the FBI basically sets the protocols for investigations. Is that an accurate description? That's right. It's basically I don't know the technical term, but it's the guide that there's AG guidelines that govern, Attorney General guidelines that govern investigations, and then the DIOG seeks to implement those Attorney General guidelines. And the DIOG, I assume, sets forth specific types of cases that become then sensitive investigations. Is that accurate? That's my recollection, yes. I assume one of those types of cases is an investigation of an attorney. Would that be accurate? I can't say for certain that that's the case. It seems likely. I mean, the two that stick out in my head are investigations dealing with the news media and then elected officials. Well, having worked in the FBI as long as you have, you know all about the FBI investigating journalists, since Obama did that quite frequently. No one talks about it, but it's true. Seems likely. Saxman Grooms. And so it sets forth categories of people or people based on their occupation that you're investigating, for which you need to set forth specific additional areas of review. Is that accurate? Different approval, different reviews. Yes. Sit up again. And so in the Clinton example, I assume that case was set into the special investigations because of the elected official aspect, the elected official aspect, the political official. I don't know what the answer to that. I don't know whether it was designated a SIM or not, so I hesitate to answer. I don't know the answer to that. Okay, so you're not sure if the Clinton investigation was designated as a special investigation. According to the DIOG, right. I believe that in the last hour you had described it as a sensitive investigation, though. Is that accurate? I don't know that I said that. I mean, dude, you called it a SIM. I don't know that I said that. I mean, we certainly, by the way it was briefed, I think in the questioning where I said it might be likely to have been, I just don't know. That would fall more on the operational side of the house, so I just don't know whether it was formally designated, a SIM. If it wasn't formally designated, it was certainly treated as such. And Jason, again, this is the director, I keep forgetting. the chief of staff of the FBI, of the director's office. He represents the director, and he runs the director's office. He doesn't know what the DIOG guidelines say about investigations. So how could he possibly represent the director when it came to things like that? I mean, he's a trained lawyer. You'd think he'd have a better grasp of FBI case law, which is how I would describe the DIOG as the law regarding the rules, the laws regarding how to run cases. He can't say that the most prominent investigation in the FBI for months, he can't say that he knew whether it was a sensitive investigative matter or not, a SIM. He can't say he knows that. He also can't say he knows when he found out about the investigation. He's absolutely not sure about that. So, not sure. Saxon Grooms. And you had said that in some sentence, right, there were investigative techniques that either required additional approvals or would not be generally taken. And I assume that for that you were thinking of specific investigative techniques against the news media. Is that accurate? Yes, correct. Were any investigative techniques not taken in the Clinton matter based on some sensitive investigation category? Ms. Redacted, Jason Ms. Redacted is Rybicki's counsel. She's from the FBI Legal Counsel Office, or OLG, one of those two. And I don't know why she's redacted. I don't know if she was in the IG report on mid-year exam, or if she's going to be in the IG report on FISA. But there's been a lot of redactions in this during some of the questioning with the Republicans. Jason says, to be honest, with your help, I learned enough to know that. Oh my God, it's going to go down. Yeah. You have been for just about all of this, so I assume you're probably ahead of me on most of this stuff. So good for you. Good for you. Thanks for putting that out there. Yes, it is. It is, and it's so scary. It's funny. It's absolutely back and forth. It's a yin and yang. You take your pick. So, Ms. Redacted, may I confer with my client? They discuss off the record. Rybicki comes back. Thank you, Saxon Grooms. Do you want me to repeat the question? Rybicki, would you mind? Saxon Grooms. Were there any categories of investigative techniques not taken in the Clinton investigative matter due to the fact that it was categorized as a sensitive investigation? So again, I don't know that it was formally designated as a SIM. Again, it was likely that it was, so I want to be careful there. And I also, where I struggle on this one, is I don't know the universe of investigative techniques, ones that may not have even come up for discussion. So I don't know that I can offer a fulsome answer to that. That's on the operational side, and you were not really on the operational side? Correct. And there's a lot of details about the investigation that you were not aware of at the time, and I assume you also now don't recall? Certainly. And one of those categories you talked about in the previous hour was a dispute or a disagreement over investigative techniques that occurred between the FBI and the DOJ. And I believe that you said during that hour you thought the disagreement was over whether to seek access at all to the laptops. Is that accurate? That's accurate. There was a little confusion as to whether the Bureau sought by consent first, which I just don't recall, and then on the second part of it, whether legal process should be sought. And access to the laptop was, in fact, received at some point. Is that accurate? Yes. In fact, the director was quite insistent that the Bureau get access to those as part of a thorough investigation. Is it fair to say you don't recall the specifics around what this disagreement between the FBI and DOJ was? I think it was. I'm not sure it was discussed in meetings I was at. Again, I don't know that I have a full memory of it sitting here. Again, it falls into one of those categories of, something that wouldn't impact what I was, dealing with in those meetings. So you don't recall the specifics of what the Department of Justice was saying, or even who at the Department of Justice was saying what could or should not be done around investigative techniques related to the Clinton matter. Is that obvious? Yes. And see that. So there she goes, getting him to back away from previous testimony by now inserting more I don't recalls, by saying just because since he does not know the exact specifics of the meeting, therefore anything he said previously should really be discounted and not taken as fact. When in fact the Republicans were very specific in their questions, and Rybicki gave them a pretty specific answer. He could not name people, but he could say it was someone from either the top of the DOJ office or a deputy DOJ personnel, and Comey and George Toscas in the meeting from the FBI. He said that directly. And now Saxman-Grooms is trying to put a cloud over that to say, oh, it never happened. Sorry about that. It never happened. This drives me crazy. Saxman-Grooms. So I want to shift topics to the statement that ultimately was given by Director Comey on July 5th. Do you recall who initially drafted the statement? Yes. Who was that? Director Comey. And what was your role in reviewing and editing the statement? Sure. So I was on the initial email from Director Comey. Again, I believed it was May 2nd, where he sent it with the initial draft. He instructed me to send it to other members of what I'll call the executive briefing team that we were talking about, so the ones that briefed the director for comment, basically. And then at various points, I was involved in collecting comments from the team and from the director, sort of going both ways. And can we just talk through briefly who was in that category of people who were providing edits or suggestions to the draft? Certainly. So it's everyone that I listed before. I'm happy to do it again if that's helpful. Actually, why don't we enter into the record the May 2nd email, and that'll make it, I think, maybe a little bit. Rybicki interrupts. Okay, Saxman-Grooms, make this Exhibit 1. So, for the record, that's Saxman-Grooms again. Exhibit 1 is SJC. It's Bates stamped SJC 140 through 143. It's an email from James Comey to Andrew McCabe, James Baker, and James Rybicki, CCing Jim Comey, on Monday, May 2nd, 2016, at 7:15 p.m. Subject matter, mid-year exam, unclassified. Is this the May 2nd email that you were describing? Yes. Saxman-Grooms. And so this would be the first draft that Mr. Comey had written of this statement. Correct. It wasn't unusual for Director Comey to consult with top advisors about matters that he was facing like this. No. You had described in the previous hour that starting from some time period, and I'm not sure you recalled when, in the Clinton email investigation, you were getting briefings regularly about it, or the director was getting briefings regularly about it, about once a month. Is that accurate? Yes. And as you had those briefings and reviewed the evidence in the investigation, was there a general consensus during those meetings that the FBI investigative team was looking for evidence of criminal intent on behalf of Secretary Clinton, but that they were not finding any? Rybicki, I'm going to parse out the question if you don't mind. Grooms, Rybicki, can you repeat it one more time just to make sure I've got it? Yes, thank you, James, for asking that question. Saxman-Grooms, sure. So you were having regular briefings, and as you were having the regular briefings, I assume that you were discussing the evidence in the investigation that was being uncovered at the time. Is that accurate? Yes. And I assume that you were also having conversations at that time about that evidence and whether it would be a sufficient amount of evidence to come up with a criminal charge. Is that accurate? I think that's accurate, especially the further along in the investigation that you went. The initial updates were very much, what was being found, especially in sort of on the forensic side. But I think that's correct. As you went further along and you began to see where the case was headed, I think that's accurate. Well, what a completely, bombshell. I hate that word, but still, what a completely bombshell answer there. That as the case went along, they were able to refine their idea of whether or not a crime had been committed. The problem is, they gathered more and more information proving that a crime had been committed, yet they decided to go to no crime was committed. And it's actually not fair to say that the FBI decided that. The DOJ decided it for them at the beginning of the investigation. I sometimes forget to cut the FBI some slack here, as people like Strzok and Page really wanted to do things right. They had very strong opinions about things like, I believe, the laptops, and also the meeting with the interview of Clinton that had probably close to a dozen people in attendance, including 2 lawyers for her who were also witnesses and respondents in this investigation. Why that was allowed, no one can explain, nor should they be able to, unless you're saying we were in the bag for Hillary and we wanted to give her every compromise we possibly could, which is exactly what it was. Saxman Grooms. And at some point, when you began to see where the case was headed, where did the consensus become that the case was headed? Rybicki, the date or the time period, is that what you're... No, the content. What was the general consensus, wow, about where the case was headed? Oh, I'm sorry, yes, right. As they were looking through all the material briefing, it became the view of the team that they were not finding evidence sufficient to recommend to bring charges. And was the lack of evidence sufficient to recommend to bring charges related to a lack of evidence of intent on the part of Secretary Clinton? Rybicki, can I confer with counsel for a second? Rybicki comes back, thank you. Saxman Grooms. And so as you were discussing the general consensus, was it related to the fact that there was not a sufficient amount of evidence of Secretary Clinton's criminal intent? I think that, so it was looking at the evidence in totality. I think that could be part of it, but I don't think it was the entirety of it. Well, as I've said so often, it's ridiculous. Intent should not have been a part of it at all, because intent is not read as part of the criminal statute. Intent is nowhere to be found in the criminal statute regarding mishandling of classified information and failure to comply with the Federal Records Retention Act, and having classified information on a private server, much less an unsecured private server. And Hillary Clinton's private server was unsecured for at least 3 months. And it has been shown, at least by one report, that the Chinese were being CC'd on every email that came and went through that system to a house in Virginia, where a Chinese agent was collecting the data and sending it back to China. But she didn't break any laws, so there's that. I mean, Dianne Feinstein's chauffeur for 10 years, he was a Chinese spy. Nothing happened to her. Rules for thee, not for me. Where's her investigation? Let's see. That could be a part of it, but I don't think it was the entirety of it. Saxman Grooms, okay. And what was the rest of it? I think it was, looking at the evidence, looking at the statutes that might be implicated in it, as well as case law, to see how cases like this may have been treated in the past. Oh yeah, there's that no case like this had ever come up before, so they had no real legal standing to file charges, which is complete and utter crap. Pardon my language. And that was an ongoing discussion that the team was having during these briefings? Yes. And that's you've been calling it the executive team? Yes. Again, I don't know at what point they started happening in the sort of timeline. Again, the early updates I would characterize as more of, just what they are finding, and then it got into this sort of level. Would you describe that the general consensus that you discussed was one that had developed before this May 2nd, 2016 email that is Exhibit 1? Yes. And is it fair to say that this May 2nd draft was at least a first draft of reflecting the consensus? Yes. Yes. I think that's accurate. I think this conveyed the director's compilation of what the team was saying they were finding, as well as those discussions. And before you received this email on on May 2nd, that you had previously discussed with the director doing this statement, in this way, sort of the contents of this email? Sure, I don't recall. We certainly discussed it afterwards. Whether we discussed it before he sent this, I don't recall. Do you recall whether the majority of the sort of Clinton emails had been reviewed before this May 2nd email? I don't remember the answer to that. And do you think that generally speaking, the classification review of the emails had been largely completed before this? I would be careful again because I'm not on the operational side. I mean, my recollection is that enough of the evidence, the forensic evidence, had been reviewed to arrive at this, but I want to be careful about, the fullness of that. Excuse me. It's time for me to refill my tea. Give me just a second. I'm going to put the clouds up. Let me mark my spot here. Okay, I'll be back in just a moment. Okay. I should remember to turn the microphone back on. This is a red letter day, folks. Mark it on your calendars. Okay. Rybicki, I want to be careful about, the fullness of that, sex and grooms. And when the director sent you this document, did he explain why he was doing so? Again, I don't recall if we spoke about it before he sent it. Again, we sent afterwards and certainly talked about it in his updates, but I don't recall beforehand. After he sent it, do you recall him explaining why he was going through this process? Why he sent the email or why he wouldn't want to do it in this way? Rybicki, make a statement in this way. Yes, why he had started drafting a statement in this way. I don't recall him saying why he specifically started drafting it. Let's see, who did we read? McCabe certainly remembered, and that was because he wanted to get it done. He wanted to get a draft done ahead of time because that way, when they completed the investigation, they wouldn't have to scramble to create a document at that point in time. However, he never had any explanation for why they only compiled a document that said that Hillary was going to go free, as opposed to also compiling one that said that they had found evidence of a crime and they would recommend and they would turn that over to the DOJ for possible prosecution. Never could explain that. And again, this was months before they interviewed Hillary and many other witnesses. I believe the account was, according to, I think it was Jim Jordan, when the Senate was investigating it, something like 12 witnesses had not been interviewed yet. Perhaps it was on this committee, I'm not sure. But yeah, 12 witnesses had not been interviewed, and they were still going to go with, there's no crime here. Yeah, makes sense. So I don't recall an explanation of why he actually sent the email, if that makes sense. Sex and grooms. And do you recall a discussion about why he would feel that the beginning of drafting such a document would make sense? I do not. At the time, on May 2nd, when you received this draft, were you and Director Comey and the rest of that executive team and the rest of the FBI team still investigating the Clinton matter? Yes. And would you characterize that the team and the director were still open to new evidence and to changing any recommendation that you had? Definitely. Well, the director might have been open to it, the team might have been open to it, but the DOJ certainly wasn't. Back to Saxman-Grooms. So if any subsequent witness interviews, including the interview with Secretary Clinton, had provided the team with new evidence or new information, is it fair to say that you would have considered that evidence and made whatever changes you thought were appropriate? Absolutely. In fact, that occurred. There was a meeting after the interview to ensure that this was still what the director wanted to do. So we have a number of documents, and I'm going to walk you through a couple of them between May 2nd and July 4th that show there were a number of communications among the executive team at the FBI about Director Comey's statement. And it also looks like Director Comey generated a number of drafts himself, reflecting his ongoing thought process. Is that accurate? Yes. Did discussions about the draft statement generally take place in email, in person, or both? I would say a combination, both. And what was the purpose in reviewing the draft a number of times? I don't know that I follow the question. Yeah, you shouldn't, because it's a stupid question. Saxman-Grooms tries to get it better. It went through lots and lots of edits. Is that accurate? Yes. Why do you think it went through so many edits? I think it's a combination, again, because when it was generated and the case was still moving forward, it was not meant to be the final draft that he would deliver by any stretch, but merely a starting point. Yes, why would you possibly consider making further edits to a rough draft, Saxman-Grooms? Why would you consider that at all? Amazingly opaque process. I also think this was the director's first attempt based on the information that the team had been discussing, but because of that, right, there might have been iterations to make sure it was all accurate, basically, to ensure, and so bottom line, to ensure accuracy of it. Saxman-Grooms. And we've seen some copies of the document in track changes and some copies that were not in track changes. Can you explain how that particular process worked? Was there one person in charge of inputting track changes to the document? I don't think there was one person, so I ended up being the sort of pivot point for a lot of them. Again, Director Comey sent this on May 2nd. I believe the deputy director forwarded it to a couple of folks, but not the whole team for comment. And then the director had asked me to send it to the entire, what I'll call, the executive team for comments. I think that was mid-May. Sure. And then from there, parts of the team would send back joint comments. It would be discussed in the briefing updates, right? And so edits would be coming in from a number of different places. Rybicki exhibit number 2 was marked for identification. Saxman-Grooms. So I'm going to mark as exhibit 2 a May 16, 2016 email from James Rybicki, May 16, 2016, 3:07 p.m. It's FBI. It's bait stamped FBI 23 through 27, and it is to Peter Strzok. Am I saying that right? Rybicki, Strzok. So I guess she didn't say it right. How could you not know how to pronounce Strzok by this point in history? Seriously. So Saxman-Grooms, Strzok, redacted. James Baker, redacted individual from OGC. Tricia Anderson, another redacted individual from the OGC. Mr. Priestap, and CC's Andrew McCabe and David Bowditch. Is that the email that you were referencing? Yes. In this email you said to this group, please send me any comment on the statements that we may roll into a master doc for discussion with the director at a future date. Rybicki, yes. And okay, that's a screw up. It should be, is that the email you were referencing? Rybicki, yes. Saxman-Grooms. And this email you said to this group, quote, please send me any comments on the statements that we may roll into a master doc for discussion with the director at a future date. Rybicki, yes. Saxman-Grooms. And if I may, Rybicki, yes. Rybicki, yes. And if I may, Saxman-Grooms, yes. Rybicki. Now we're back on schedule. Now that I'm looking at this, I realized in response to the previous round of questions I left off a couple individuals as part of that team. I can supplement that now, or, Saxon Grooms, sure, that would be great. Rybicki, just forget on the operational side you had your, so under the deputy director side you had your EAD, Executive Assistant Director, for National Security as part of the group, who was Mike Steinbach. We are not going to hear from Mike Steinbach in this series of of transcripts. I think he was for the entirety, but if I remember differently, I'll let you know. And then the Assistant Director for Counterintelligence, that did span 2 people. So it was Randy Coleman initially, and then Bill Priestap. And I believe we have already read Mr. Priestap into the record. And these 2 redacted OGC counsel, can you tell me who they are? So there's a lot of emails with redacted OGC counsel. Ms. Redacted, let me just, off the record discussion, Rybicki comes back, thank you. Saxon Grooms, can you tell me who the redacted OGC counsel are? Sure. To the best of my recollection, it would have been Lisa Page and redacted in the Office of General Counsel. I want to move to a new exhibit in this sequence. We're marking it Exhibit 3. It is an email from Peter Strzok on May 17, 2016 at 4:35 p.m. It's to you. It CCs Andrew McCabe, Priestap, redacted, and a redacted OGC counsel. It's bait stamped FBI 49 through 50. Do you recall this email? I don't recall specifically, but I don't dispute that it came to me. Excuse me. Saxon Grooms, So the email starts, Jim, blank, John, and I thought about and then spent a few hours talking about the director's request. Some of our overarching observations follow as he narrows down what he wants to say. We'll provide comments about specific numbers, fact-checking. Do you know who the redacted person is at the beginning? Rybicki, I think I could, given the context. I think I could say, but I'm not certain for sure. Who do you think it is? Lisa Page. When you read through these comments and this email, did you consider them to be Mr. Strzok's comments alone, or was he consolidating the comments of the group? 12:25 p.m. Mr. Rybicki, I would have said, because this happened frequently, the consolidating the group. That's what that says. Let's see, they're at 12:25, we're at 12:32, so we've lost 7 minutes due to my babbling. I'm sure we'll catch up. Saxon Grooms, and who could have been in that group? Who would have been in that group? So I guess I would call it a subset of the executive briefing group. So Mr. Strzok, Mr. Redacted, Lisa Page, redacted. So sort of the investigative team plus some of their counsels. Saxon Grooms. So he separated these comments into 3 parts. Under thematic considerations, he said, and I'll quote, the entire thing is redacted. When you got these comments from Mr. Strzok on behalf of this group, did you feel that they showed that he and the team wanted to aggressively rebut statements that had been made by Secretary Clinton in her campaign, that they had evidence that they felt that they could rebut? Or is it rebut? I think it's rebut, actually. Sorry about that. Yes, rebut. My mistake. I don't remember feeling that reaction. No. Do you recall any reaction to this? No. Again, typically, as sort of the pivot point for these, it would have been sort of consolidating them and either servicing them in the briefings or inputting them in sort of a track change document, something like that. I think something like this would probably be raised, either I would have forwarded it to the director or then raised it, for discussion at the briefing. Saxon Grooms. Do you recall further discussions with the director at the briefing about this subject? In response to the first line, I don't recall specific discussions. Excuse me. I recall a lot of discussion about the sort of so-called classified, I think that's what they called it at the State Department. I recall a lot of discussions about that, whether, something is something unclassified, at the time you sent it, but then later it can be upclassified, raised to classification level. So I know there was a lot of discussion on that, which could be a part of this. Let me just interject for a second. Upclassification means nothing as far as whether or not that document was unclassified when you received it. If it's in your control and it's upclassified, you're responsible for treating it as a classified document. There's a very famous case of a CIA employee who left the bureau, or who left the agency, and at his home he had some documents that he had brought with him. Were they illegally brought to his place? No, they were not. They were unclassified documents, and he had the right to hold on to them. As I understand it, if I'm wrong, please feel free to correct me in the comments or in the in the comments in the discussion. But one of those documents was upclassified. The CIA came after him because they knew he had that document, and he went to jail. So there's nothing in the Clinton investigation that would have saved her from an upclassified document being on her server or on her laptop or on her BlackBerry or whatever. It doesn't count. There's no do-overs with classification. Saxon-Grooms. He also, in the second part, discusses the question about whether there would be a perception that Secretary Clinton was receiving special treatment. It says, and I quote, and that entire paragraph is redacted, "Did you think that the FBI was treating Secretary Clinton differently than it would anyone else? No, I think she was being treated as what a person in her position would have been treated." Oh, my poor naive field mouse. Or my lying sack of what. Take your pick. Saxon-Grooms. And did anyone in the team actually express that they wanted to give Secretary Clinton special treatment? No. Was there a concern within the team that there would be a perception that Secretary Clinton was being treated differently than others? Can you repeat that one more time? Yes, in other words, can you ask the same question you just asked before again? Sorry, that's me. Saxon-Grooms, yes. Was there a concern within the executive team that there would be a perception that Secretary Clinton was being treated differently than others? I think that's fair to say. I think, when you're looking at a case, you want to look at the totality of it, right? And again, going to this point of, were others, were they treated differently because of the person they were rather than the facts of the case? Person they were rather than the facts of the case, if that makes sense. And did the team have discussions about that? I think that's fair to say. And what did the team decide to do about the concern about the perception that she would be treated differently? I don't know. So I don't know how to go into that concern that she would be treated differently, but that this case, right, the decision not to charge or to charge or not to charge might be differentiated from other cases that were charged or not charged. And how did the team decide to deal with that issue? I think that was dealt with in the statement and by looking at the statutes, looking at the case law, and then, just making sure that it fit into that structure. So by taking the facts of the specific case and trying to describe how it fit or did not fit the previous cases that have been prosecuted, sure, yes. At the end of the email, on the second page, under section called Topics for Further Discussion, there's a point 6, quote, whether her conduct rises to the legal definition of gross negligence, unquote. Do you recall whether the senior leadership team discussed whether Secretary Clinton's conduct rose to the legal definition of gross negligence? I remember a lot of discussion surrounding the statute specifically and what would have been required for it, and applying the facts and the evidence of this case to that, as well as, again, the cases that have been brought. But I don't, and so there was a lot of discussion around that. And did the team consult with the Office of General Counsel on that question? The Office of General Counsel was a participant in those meetings, yes. And who from the Office of General Counsel would have weighed in on those issues? Again, I can't. So the General Counsel was a participant in most briefings, as well as Tricia Anderson and redacted from the Office of General Counsel. Whether they weighed in specifically as to that point, that's, you don't recall? I don't recall. They were certainly present and had the opportunity to weigh in. And let me just interrupt briefly. As I have said before, Tricia Anderson is going to be closer to the end of, she's near the middle, but closer to the end of the list I've got here for people to be read into the record. She's, let's see, we're doing Rybicki 1, 2, 3, 4. She's 4 away from where we are right now. I tentatively have her scheduled for the 12th and 13th of June. But again, when the IG report drops, if it drops in the middle of this set of transcripts, then I'll have to push things back to accommodate that, because I will, of course, be reading the IG report as soon as it comes out, as long or as short as it may be. And if it's anything like the first IG report, it's going to take a while to read, folks. We'll see. We'll have to see. Because I think it took me 25 or 28 hours of straight reading with just 5-minute breaks from like a Wednesday afternoon to a Thursday evening. I didn't even sleep. Well, I did fall asleep a few times while reading, but that's my general technique anyway. So what can I say about that? Okay, so Rybicki will repeat the last sentence. Whether they weighed in specifically as to that point, that's Saxman Grooms. You don't recall. Rybicki, I don't recall. They were certainly present and had the opportunity to weigh in. And in those discussions, did the Office of General Counsel consult, or the people outside of the Office of General Counsel consult case law and precedent? Yes. And what was the result? Did you or did they find a robust body of law for charging non-military government personnel under the gross negligence standard? I just named an instance, lady. Rybicki, can you unpack that just a little bit for me? Saxman Grooms, sure. What was the result in terms of the conversations around the gross negligence standard? So I don't recall specifically to the gross negligence standard. Again, I recall a lot of discussions surrounding the statutes, right, and how they would fit. As to that one in particular, though, I just don't know the specifics on that. Like I said before, James Rybicki don't know a lot about nothing. And what do you recall about the discussions surrounding the statutes and how they would fit? Sure. Just again, how, the case law in particular, and how the criteria that would be needed in order for the government to bring charges against someone, and how the evidence that was gathered in this case would fit into that. And what was the conclusion about the evidence that was gathered in this case and how it fit into that? So I think, Mr. Schools interrupts, can I ask you to clarify that question as to whether that's a conclusion of the team or a conclusion of the General Counsel's office? Saxman Grooms, sure. Schools, I would like to sort of go to the core of attorney-client privilege conclusion. Sure. Saxman Grooms, sure, the conclusion of the team is fine. Schools, thank you. Rybicki, yes. So I guess I would go with Director Comey's characterization of that, which would be that no reasonable prosecutor would have brought the case. And that was why Comey was fired, in part because he's an incompetent boob. Saxman Grooms, and that was the consensus of the team. I think that's accurate. And again, because the DOJ was on their neck. I wonder, even if Comey would not have come to the decision to not prosecute. And remember, he said, we're not going to prosecute. Maybe he did say we're not recommending prosecution. And the DOJ then said, yeah, we're not going to prosecute. Or Comey just said outright, no prosecution, and we're done with it. I believe that's what he said. I've got to go back and read that July 5th statement. It's been quite a while. But he could have come to that conclusion on his own, or he could have been under the weight of Loretta Lynch and the DOJ in whole, and went against his better judgment. We'll have to see. That's going to come out, I'm sure. But where was I? Oh yeah, Comey still screwed up a bunch during the investigation. The way he handled the quote-unquote end of it on July 5th, and then the way he handled the reopening of it back in late October, and the fact that they slow-rolled reopening it when they knew the information was in the hands of the New York field office as early or mid-September of that year. So, yeah, Comey was a complete screw-up. There's no doubt about it. Let's see. Saxman Grimm's. In the initial draft that Mr. Comey sent around on May 2nd, there was a sentence that included the term gross negligence, and then that was later removed. Do you recall who removed it or why that decision was made? Sure. My God, he remembers something. Sure. Number one, consistent with what the chairman outlined, So I've heard media reports, right? That it was Mr. Strzok that changed it. So I just want to make sure that that's, according to the media reports that's in my head. I don't recall on my own, because of the iterative nature of the document and how they were coming in groups and batches like this, as well as discussion. So I can't sort of pinpoint one person independently. You just said you could. Okay. Maybe you meant why the decision was made as opposed to who. She asked both, which just goes to show again why she's such a crappy investigator. So, okay. Rybicki's last part, so I can't sort of pinpoint one person independently. Do you recall the discussion about why that change was being made? I don't. I think it's consistent with what we just talked about of, so the May 2nd email, Exhibit 1, being the director's first attempt at sort of bringing this all together in a way that he would say it, and then the team talking about, again, wanting to ensure complete accuracy on it. So is it fair to say that the edit of removing gross negligence reflected the team's general opinion after discussion and research? I think that's right. I wouldn't ascribe it to one person that I can recall. Do you recall anyone disagreeing with that decision? I don't. Again, anyone disagreeing, I want to make sure I said that, with that decision. I don't. Again, there was robust discussion about the statutes and the standards. Again, given my role as the chief of staff and how I was involved in these discussions, it's not something that I sort of clued in on. And so I can't say for sure, but I just know that there was a lot of discussion. Hiller, I think that's about an hour, so we'll take a break. That went much longer than I expected. Rybicki, could I just have 1 second with my attorney, and then I want to say one more thing? Hiller, we'll wait right here. Sure. Rybicki discusses off the record. Saxman Grimm's, did you have anything you wanted to add? Rybicki, thank you. If I may, just reflecting on one answer I gave before, I just wanted to make sure because I don't think I artfully said it. You had asked about whether something to the effect of whether Secretary Clinton was treated differently, and I think I said something to the effect of, we treated her, the same as anybody in her position. I didn't mean to convey that the position was Secretary of State or anything like that. What I meant to convey was sort of the totality of the circumstances for any individual. I just want to make sure that was clarified. Hiller, clarified. Thank you. Saxman Grimm's, thank you, Hiller. We'll take a break now. We'll go off. And there's a recess. Gotti, back on the record. I think I addressed you incorrectly as Special Agent Rybicki. What is it, Mr. Rybicki? That's fine, Mr. Chairman. I appreciate the accolade of Special Agent, but, Gotti, well, if you went to law school, you earned something other than Mr. I just want to address something up front before I start asking you questions, and it's important to me. I don't really feel like I need to clarify it. I just want to. I do think 2016 was a difficult year for the Bureau. It was also difficult for some of us that were defending Director Comey when there weren't very many people doing it in the fall of 2016 and even into 2017, even continuing to this day in some instances. Excuse me a moment. Gotti continues. So when I say it was a difficult year for the Bureau, I really don't think there can be any cross-examination of that. There was a presidential candidate under investigation. There was a campaign official, either officially or unofficially, connected to the Trump campaign. People can quibble about that. Also under investigation. One was made public, one was not made public, but the nation's premier law enforcement agency was involved in both of them. The July 5th press conference, where many Republicans have defended Director Comey's decision to have that press conference, nonetheless was a difficult decision to be made. That is not usually a decision that a law enforcement official makes. This is a charging decision that is left to the prosecutor. What went into his decision to have the July 5th press conference, and there's some of those matters we can't discuss in this setting, and some of them we can, but those are difficult things to weigh and balance. And the decision to write 2 letters in the throes of a major political race was a difficult decision to make. So I think you may actually have said it best. Quote, reasonable minds can differ about whether or not that decision should have been made or not. I think the Bureau and Main Justice are big enough to explain the analysis that they used to reach the decisions that they reached, and people are welcome to agree or disagree. They can say that they would have reached different conclusions. I just think the Bureau and Main Justice are big enough and strong enough and competent enough to explain whatever those decisions were. I wonder if that was a quote or not. That really went on a long time. I think he was just paraphrasing. I didn't see any close quotes on that. So he continues. I would also, let me say again, it's Gowdy, right? Yeah, Gowdy continues. So I think you may have actually said it best. Reasonable minds can differ. No, I just read that. Sorry. Gowdy, I would also hasten to add this. It was not any member of this committee, and it wasn't any member on my side of the aisle, who accused Director Comey of a double standard that intentionally politicized the presidential race. And it wasn't anyone on my side of the aisle who referred to him for criminal prosecution under the Hatch Act. Those would have been Democrats. Those have been Democrats that did that. So I do appreciate the fact that they want to now canonize some of the people that they once wanted to indict. I give them a lot of credit for being able to pivot in a relatively short period of time. But just understand, at this time last year, all of the praise being lavished today on the Bureau wasn't being lavished on the Bureau. There were calls for the director of the FBI to be prosecuted for a crime. So against that backdrop, I'm going to ask you a couple of questions that I have going through my head, and then turn it over to Johnny and anyone else that has questions. Mr. Rybicki. Thanks, Mr. Chairman. Okay. Applause to Gowdy. Once again, he cuts through all of it in just a couple paragraphs. I blather on and on about it, and Gowdy just goes with a broadsword, cuts it in two. The Gordian knot is unraveled, and it is all laid bare. Thank you, Chairman Gowdy. Okay. Gowdy. The decision to confirm or deny the existence of an investigation. Policy is traditionally to neither confirm or deny, nor deny. Is that a Bureau policy, a Main Justice policy, or both? Rybicki. I think it derives from the U.S. Attorney Manual. I don't know whether there's a specific FBI policy on point to that, but I certainly think the common practice is exactly as you articulated for both the Bureau and the Department. And is that the reason that the director of the FBI had a conversation with then Attorney General Lynch on whether or not to make it public and what to call it if it were made public? Mr. Chairman, the conversation, the meeting at DOJ that I mentioned and described was again in both the Attorney General and the Director were going to be making public appearances, and again, I believe they were both congressional testimony. And in the context of the time period of which it happened, it was the assessment of, at least on the Bureau side, that it would undermine the credibility of the Bureau to not say anything to try to hold that line, meaning it would be nonsensical to try to no comment, even in the context of the traditional practice. Excuse me. Okay, if I may, I'd like to know why that's the case. I mean, seriously, sorry, I really spiked there. I'd like to know why you determined that you could not just no comment, because remember, the policy is do not confirm, do not deny. The press reports, of course, were leaked by the FBI directly to WAPO and New York Times. So there was some subterfuge going on there. I don't know if the FBI saw that Clinton had committed those crimes and decided that they wanted to undermine her as best they could by leaking out that she was under investigation to cover their butt, in case the DOJ told them to find no crime, which is what happened. Or if McCabe and Page, who I believe were the leaks, were just of the mind that, hey, I need to keep my New York Times and WAPO people happy, so let's throw them a couple bones with meat on them and stay the course. I have no idea why they did it, but we know that they did it. Okay. Even nonsensical to try to no comment, even in the context of the traditional practice. Gowdy, did the attorneys at Main Justice agree with the Bureau's assessment that it would undermine the credibility of the Bureau to act as if an investigation were not ongoing? Rybicki, I don't know the answer to that, Mr. Chairman. Gowdy, so it is your belief, well, maybe not your belief, but the Bureau's position, that the Bureau could make that decision independently whether or not Main Justice agreed? I think one of the purposes of the meeting was to try to coordinate with the Department of Justice on that. And was there consensus between the Bureau and Main Justice that it should be made public? No, I'm sorry, the decision whether to make it, I was not thinking correctly, so I was parsing the investigation versus the matter. But you're saying at all, Gowdy, at all. I don't remember that level, Mr. Chairman. I want to say there was agreement that it should be acknowledged, but how to describe it was the question. That's my general recollection. All right? And I think you walked through a previous line of questions the various factors that the Bureau would consider and whether or not to break from normal protocol and make a mistake. Excuse me. Gowdy continues. It's not a statute or a law. It's a policy decision. You walked us through the factors that inform and instruct the decision to depart from normal practice. And what were those factors? I believe there's more than 2 in the U.S. Attorney Manual. The ones I recall, though, are sort of extreme. Public danger, if if the public's in immediate danger and the government needs to confirm that they're doing something about it. Or, and again, I don't know if this is the exact wording, this sort of extreme public interest or great public interest, if it is in the public's interest. So not so much that the public might be interested in it, but if it's in the public's interest. Is it fair to say that the grave danger to the public factor would not have been the decision maker in this fact pattern? Rybicki, I think that's fair. Excuse me. Shouldn't be happening. Gowdy, all right. At some point, the Bureau also had to decide whether or not to make the investigation into a Trump campaign official public or not public. How would the analysis be different? Because in one instance, you decided to make it public, and in one instance, it was not made public until after the election. Walk us through how you reached different conclusions. Sure. I think to start, Mr. Chairman, is just to, and this is definitely my view. Every case stands on its own, right? So what you do in case A should have no bearing on what you have in case B. Try to balance them in some way, whether you're talking about this particular example or any other, I just think it would be totally inappropriate to try to balance them. So just because you did in A, right, you should try to balance that with B. So that's where I start from on it. I think how you differentiate the two here would be all the factors that led into, so that proposition aside, the factors of the time period that you were in and all the factors. So the Clinton email investigation had been going on for some time, and again, there were factors that went into wanting the department of the FBI to confirm it publicly, right? Which we talked about in that meeting, or was the subject of that meeting. For the other investigation that you referenced, my recollection is it was relatively early in the case. There was nothing to announce at that point, right? Because you had no predicate. There was absolutely no reason for you to start that investigation except for Hillary Clinton's campaign saying there's a bromance between Trump and Putin, and we think they're influencing the election. That's all you had. You didn't even have the dossier yet. Wait, let me back up a second. No, that's right. Crossfire Hurricane was initiated under Comey, um, and they say it started July 31st with the transmission from the High Commissioner to the UK, Alexander Downer from Australia, saying that George Papadopoulos had told him that, now here's the thing, he had just told him that the Russians had something on Hillary. Downer explained later on, Papadopoulos never used the word dirt, he never used the word emails, that all Downer could come up with is that he said something about that. And Downer was recording that conversation. That much is obvious in George's book. Patently obvious. And if you don't want to read George's book, I'll put the links in the description. Let me write it down here. You're going to want to link to Fleckus Talks. He did a great interview with George. There's another interview that I did with Mark Stein, who's a great political commentator. That was an excellent interview. I'll link that. There's a third interview I did not watch. I'm just not a fan of the guy's technique. Don't get me wrong. I'm not saying he's a bad interviewer. I'm not saying he doesn't know his stuff. In fact, it's Michael Tracy, formerly of the Young Turks, before Cenk fired him for not towing the party line on the Russia investigation. Michael Tracy told Cenk that he was basically, he didn't say this word, but he basically told Cenk that he was an idiot about his perception of Russia. And Cenk took it, but you never saw Tracy on the main dais again. And then Dais wound up quitting because of I'm sure because of the atmosphere that they placed him in at TYT. But anyway, Michael Tracy did an interview with Papadopoulos. I've got it queued up. I just don't know if I'm going to watch it or not. But I'm sure it's worth the effort to look into. So I'm going to link that as well. And, oops, Fleckus again. Tracy. And I'll put here also the video. So what I'll also do is I'll put these links. Oh yeah, George's book. I'm going to do that again. George's book. I'll put all those links in this description, and I'll also put the links that are missing from this list in the Papadopoulos interviews description, so people can see that there. And while I'm talking about descriptions, I'm going to mention this video. I may mention it once in the subsequent videos as well, but only once. I have a PayPal donation page, or link, I should say, that's in the description. If you feel or think, I would rather use the word think, if you think you would like to throw some money at the channel, I'm not asking for it. I'm not asking for numbers, amounts. I'm just saying, if you would like to help support the channel a little bit or a lot, whatever you feel, damn it, think, go ahead. It's up to you. No pressure. It's not that I'm destitute. It's not that I can't keep this channel going. I'm just saying, if you would like to offer something as appreciation for the work, then please go ahead. If you feel, however, that I'm wasting your time, then not only don't donate, but put that in the comment section so I'll know. That will help me determine maybe that I need to filter these videos better and come up with people who are more in the public eye and who would be more sexy, if you will, to put their transcript on. For instance, I've got Loretta Lynch coming up at the end of this, and of course Trisha Anderson, who's mentioned quite often. Sally Moyer, who's mentioned quite often, but not a lot of you have heard about Jonathan Moffa. He's been mentioned once or twice, but not a lot. Now, William Sweeney, you've never heard of, but I think he's going to be one of the most important of the transcripts because he was the director of the New York field office when the Wiener laptop came in. And he can shed a lot of light on how quickly and with what amount of effort the uh, the executives, the executive building at the FBI, Comey and Strzok in particular, went after that laptop after they notified them that it had Clinton emails on it. I think that's going to be a very, very interesting discussion. It's only 114 pages. We're at page 94 right now. I started reading at 10, so it's been 3 hours. So it would basically take me 4 hours to read all of that with commentary. So and definitely be a short read, but I think it's going to be very important. So we'll keep that in mind. But again, if I'm wasting your time, if you'd like to see different videos, if you'd like me to parse down or skim down this list, remember, all these are listed in the video that I did just last week before, about who I had lined up and what dates they were going to be read on. If you feel that some of these are not worthy of time, tell me in the comments. Let me know. They're all listed in there. I don't have to read them all to you now. They're on that video. You can comment on that video. You can comment here. You can comment anywhere you want. I read all the comments. I respond to quite a few of them. And I'd be happy to know your opinion. I really would. I'm here for you, basically. I'm doing this as a pet project, but I want you to be interested in it. If you're not, let me know, and we'll see what we can do. Thank you. All right, rant over. Okay. Rybicki's last phrase, it would not be in the public's interest to disclose it. Gowdy. But it would have been true at some point in the summer of 2016 that an official of the Trump campaign was under investigation, either from a criminal or counterintelligence standpoint. Excuse me. Talked myself dry. Rybicki. Mr. Chairman, I don't remember the exact time period. My recollection that it was late summer, like late July and August. Gowdy. It was late July. Rybicki. Yeah, so I want to be careful with that, but I'm sorry, your point there, I lost my train of thought. Well, one of the criticisms from our friends on the other side of the aisle is that the public was made aware of one investigation, but they were not made aware of the other. And I appreciate the fact that you don't treat everything exactly the same, because even the smallest fact can influence it. But you had a presidential candidate and a presidential campaign. You had one under investigation for a potential mishandling of classified information, and another under investigation for something else that's also serious. And the Bureau made the decision to make one public and one not public before the election. Now, ultimately, Director Comey did make it public, and if memory serves me, he made it public in January or February of 2017. Rybicki, my recollection is March, Mr. Chairman, but if we're thinking about the same hearing, I believe it was, Gowdy, you may be right, Rybicki, House Intelligence, Gowdy, maybe in early March in a public hearing in the Ways and Means Committee room. Yes, Mr. Chairman, that's the one I'm thinking of. All right? And what factor existed in March of 2017 that did not exist in October of 2016 that would have led you to make it public at one point, but not the earlier point? Well, that's answered by the fact that either Brennan or Clapper, I always forget which, made Comey brief the president on the wet works done by the prostitutes in supposedly done by prostitutes in the hotel room in Russia, in Moscow, and Trump behaving very oddly. Comey briefed him on that part of the dossier, and then said, "We're looking into whether or not you've got people connected to Russia in your campaign, or had people connected." And Trump said, Find them all. Find them all. Some words to that effect. Now, I don't think Clinton said, make sure I didn't do anything wrong. I don't think that happened. But once Comey briefed the president-elect, because Trump hadn't been sworn in yet, once he briefed the president-elect on that part of the dossier, he gave himself the go-ahead to go to the press with that, which is what Clapper/Brennan wanted all along. And that started them down the road to the special prosecutor, which is, again, was their long game. I'm sure of it. I'm absolutely sure of it. I wouldn't be surprised if Comey resisted Trump's appeals to name him as not being a target in that investigation, that it was his campaign that was under investigation. 3 times he asked Comey to do that, and Comey refused. I think it's very possible that Comey refused specifically to make Trump fire him, to be a sacrificial lamb, because that's the way Comey thinks. He thinks of himself. And he probably thought that would elevate him to supreme importance in the investigation as a martyr. And then the special prosecutor office would be enacted quite quickly, which is exactly what happened. And I'm not going to put it above Clapper and Brennan and Comey and McCabe and possibly Rybicki to think that through and figure that's the conclusion they would get. I think it's entirely possible. In fact, I think it's probable. I'd like to be proven right on that. That would be a nice prediction to come true. So Gowdy asks Rybicki, what factor existed in March 2017 as opposed to October 2016 that made the Crossfire Hurricane investigation public, or at one point but not earlier? Rybicki says, Mr. Chairman, I don't know if I can speak to the exact thinking at that time. I think that a factor would be how far the investigation had come to that point, but I don't remember all the factors. There was definitely discussion and coordination with the Department of Justice at the time, as well as to whether to make that announcement. Chairman Gowdy, do you recall when Senator Reid sent the letter suggesting that Director Comey had violated the Hatch Act? I don't recall who actually suggested it. I know that it was, in fact, done. I don't recall who sent the letter. Gowdy, it was Senator Reid, who was the majority leader in the Senate at the time, or may have been the minority leader at the time. The decision to send the first letter to Congress, were you part of that decision? Yes. And walk me through the various factors that informed and instructed the decision to, number 1, send the letter, number 2, make it public. Certainly. You're talking about the October 28th for clarity? Yes, the first of the two. Yes. Thank you, Mr. Chairman. So I think when the director was notified about the possibility of additional emails being found, there were two decisions that he made. It was teed up for him whether to seek legal process to be able to let the agents look at those emails. So that was decision 1. The second decision was, and I believe Director Comey raised it, was having testified that the Bureau had completed its investigation or concluded all investigative action. Taking a step like getting legal process for him to view them would require some notifications that, and he felt that was his obligation, is the bottom line as the person who, in fact, testified to it. That was one of the excuses Comey gave for telling Trump that he couldn't give him the absolution of not being under investigation in Crossfire Hurricane, because Comey said, well, if I tell people that you're clear, and then it turns out you're not clear, I'm going to have to go back and do it again. Well, he's already president, so you're not going to hurt him any more than you already have. You've already got him under a big cloud of suspicion. People are saying that he colluded with Russia. already, even though obviously you said to him that he wasn't, it was just the team. So there was that. That was all over the news. So announcing that would have been a non-event. But since you did it with Hillary, you were gun shy and Comey, and it just again shows how crappy of a director you were. Didn't even have the courage of your office to back you up. Rybicki continues, as the person who in fact testified to it, the forum then was subject to discussion amongst the group, and one member of the group, an attorney, made the suggestion to send it in a letter to the chairman and ranking of select committees, select meaning a couple committees. And so we talked a lot about whether that letter could be, well, stepping back a moment, whether any communication could be classified, and in fact, we decided this couldn't be properly classified under the criteria for classification of national security documents. And then it was this attorney's suggestion to send it to the committees as a way of learning that the director needed to supplement his testimony, and we took steps. So when the director gave his July 5th announcement, he sent an email to the workforce. Obviously, he was going to give a public statement, and then he wanted as is typical when he made big decisions, he sends an email to the workforce. He just said July 5th, and we're talking about the October letter. So I wonder if he's just backing up to give context, or if he got the date wrong. I can't quite tell. Continue with Rybicki. When he sent the letters to the chairman and ranking, he sent it up to the Hill, and then we had a draft email ready to go. We purposely did not send it under the theory that it may not get out. It was likely that it may not get out. Interesting. It was likely that it would get out or be released publicly, but that it may not. And if it didn't otherwise get out, the Bureau was not going to say anything about it. Gowdy, I understand your testimony correctly. If I understand your testimony correctly, there were two factors, and I may be overly simplistic, and if it is, you correct me. Number one, there was a prospect that you may have to use legal process, and it would get out that way. Number two, the director had testified before a committee of Congress that the investigation had concluded, and he felt the need to supplement the record and make it accurate if, in fact, the investigation were reinitiated. I think that's fair, Mr. Chairman. And I would only add to the second point, which is, it was Director Comey's view that to take no action would, in fact, be concealing the fact of. Gowdy, let's assume for the sake of argument that the director's correct. Are you familiar if I use the phrase Gang of Eight? Are you familiar with what I mean when I say that? Yes, Mr. Chairman. Was there any discussion of notifying Congress at the Gang of Eight level? I can't recall, Mr. Chairman, when the suggestion was made to notify Congress, and I think it was, to the best of my recollection, it was made to those specific committees, because that's to whom he had testified. I don't recall if there was discussion at the Gang of Eight level, but I'm familiar with the term. In one of the questions raised by my colleagues on the other side of the aisle, but it's a reasonable question, is whether or not you had any other alternative accepting that the director believed he needed to supplement the record, accepting the belief that he thought to do otherwise would leave a misapprehension in Congress's mind. Just give him that. Excuse me. It didn't have to be public. There are lots of ways to notify Congress that you would like to supplement the record. You can go in a SCIF. And of course, a SCIF is a secure room in which the document is available for review by certain members of Congress, usually just a committee chair or a committee counsel, maybe the two, of both the ranking and the majority side. But no notes can be taken, no instruments, pens, pencils, phones, whatever, can be brought into that room. So you can only read it and then take away your recollection. And you are not to comment on it to the public. That's a SCIF. I believe it. I believe it stands for Secure something information facility, something like that. Um, I'm probably wrong on that, but basically it says I described. It's a secure room. A SCIF is a secure room, and the process involved around it. So you can go in a SCIF. You can do it at the speaker and minority leader level. It doesn't have to be in a letter. So what other alternatives did you consider other than what you opted for? I don't remember the specifics, Mr. Chairman. We talked about, in fact, giving a public statement, updating it that way, because the testimony had been public. So I don't remember the universe of options, but I believe you are correct. I think I think we saw it as the best option at the time, but fully stipulate that there probably were other options. Gowdy, who at the Bureau was authorized to talk to the media on the record? Rybicki, sure. It's enumerated in the media policy, which has just been updated. They include the director, the deputy director, the associate deputy director, the assistant director for public affairs, special agents in charge, and ADICs as they relate to their areas of responsibility, various public affairs specialists that are authorized, and then anyone else with approval of that group, basically. Thank you, Picasso Nose, once again, coming through in the clutch to dig me out of my holes, or to give me a ladder to climb out of my holes, I think would be a much better way to put it. You can dig someone out of a hole, but it takes a long time. A ladder is much quicker. Anyway, Picasso Nose says that SCIF stands for Sensitive Compartmented Information Facility. Awesome. Awesome. Compartmented was the part that was throwing me, and you can see why. That's a pretty tough word to remember. But sensitive information facility, very nice. Thank you, Picasso Nose. And I hope everything is okay. Just give me a general thumbs up or whatever in the chat to let me know that there's no serious things going on right now. I'd appreciate it. I'm guessing so because you came back fairly quickly, but I want to know for sure in case you need me to get off or something. Let's see. Rybicki, various public affairs specialists that are authorized, and then anyone else with approval of that group, basically. Gowdy. Thank you, Picasso Nose. I appreciate it. Okay, everything's good. Wonderful. Gowdy. Who at the Bureau would need to authorize off-the-record conversations with the media? Rybicki. I believe that same. I treat on the record or off the record. I would consider them to be the same. So everyone at the Bureau does not have license to talk to anyone in the media that they want to talk to, correct? If you're not in that designated group, is it clear within DOJ policy that you are not authorized to talk to the media? I think it was, what I would say, ambiguous before, even though there was a policy. It has now been clarified with the new FBI policy, and I believe DOJ has a new policy as well. Yeah, you guys still haven't stopped the leaks. At least you made it more official as to who can talk and who can't, which means it's going to be easier to prosecute people for leaking. But they're still there, folks. You guys are a sieve. Rybicki's last statement, I believe DOJ has a new policy as well. Gowdy, I'm going to let Johnny jump in here for a second. Ratcliffe. Mr. Ratcliffe steps in. Mr. Rybicki, I want to follow up on some of the questions that the minority just asked you relating to what's been marked as Exhibit 1. So I want to give you a chance to pull it out. I know you said you reviewed that document before your testimony today. Rybicki, yes, Mr. Chairman. Ratcliffe, I want to make sure some specific references to you, and I want to make some specific references to you, and I want to make sure that you have every opportunity to look at it so we can kind of go through this together. But I want to go through it because it's very important to try and understand the decision-making process that went on here with respect to that. So my first question is, was Exhibit 1, this May 2nd email, was it Jim Comey's idea? Mr. Congressman, I don't recall discussing it prior to this. It's possible. I'm not recalling it. He is the one that initiated the draft, though. Okay? And so did he actually draft it? I believe that's the case. Okay? So to the best of your knowledge, these are his words, correct? I may stop reading that, okay, folks. I just can't stand it. It's going to drive us crazy. Ratcliffe. And it would have been based on the multiple briefings that he would have had from the mid-year team up to that point. Yes. You know, as I read this, we can refer to it as an email. It reads to me, we talked a little bit before about our backgrounds. It reads to me a little bit more like a non-prosecution memo in the sense that it talks about the FBI's investigation, and then it runs through the specific elements of the statutes at hand, and then concludes with the director's opinions about prosecutorial discretion. Do you think that's a fair characterization of this? Call this essentially a draft. You've called it a draft, but essentially a draft non-prosecution memo? Rybicki. I wouldn't call it that. I considered it for what it is, a recommendation to the Department of Justice and public statement. So I wouldn't go as far as calling it a non-prosecution memo. Or, Ratcliffe, okay, well, have you seen non-prosecution memos? I have. Have you ever seen the FBI director draft one? No. But a non-prosecution memo would go through some of the things that the FBI director did in this case. Would you agree with that? I think that's accurate. So, to your knowledge, did Director Comey at any point in time do whatever we're going to call this, a draft email, with respect to potential prosecution of Secretary Clinton? No, Mr. Congressman, that's Chairman to you, buddy. No, I think, for the same reason I would have just said, right? Because this was the recommendation of or based on what the team was telling him up to this point, that this is where it stood. It was not meant to be final, I guess, so I would add to that. Dude, you're dancing around the question. You just said it meets the standard of a non-prosecution memo. And then Ratcliffe said, so to your knowledge, at any time, did Director do whatever going to call this with respect to potential prosecution of Secretary Clinton? Yes, that's exactly what that memo said. How can you possibly dance around that? Again, Rybicki quit 5 days after this interview, and I think we can see why. Ratcliffe. So specifically again, the director goes through in his own words and talks about a specific statute, 18 U.S.C. 79.3f, and regarding the handling of classified information and the elements of that. And he sort of summarizes, under the first part, what the investigation was towards the bottom of the first page, where he says, our investigation focused on whether there is evidence that classified information was improperly stored or transmitted on that private system in violation of a federal statute that makes it a felony to mishandle classified information either intentionally or in a grossly negligent way. Dude, how can you not find her guilty of that? How in God's green earth can you not find her guilty of that? Now, Ratcliffe, did I read that accurately? Rybicki, yes, sir. Okay. So then he goes on to talk about that in greater detail over the next 2 pages, but on 2 separate occasions, Director Comey in this first draft apparently expresses his opinion, not once, but twice, that he believes that Secretary Clinton and others were grossly negligent in the handling of classified information. Is that accurate? That's accurate. Okay. Was there any discussion at that point in time that, given the fact that the role of the FBI is to investigate whether or not a subject or a target has committed the elements of an offense, that at that point the FBI opinion of this executive team was that Secretary Clinton had committed the elements of an offense, to then hand this matter off to the Department of Justice to exercise their prosecutorial discretion? Rybicki, I think I lost a little bit of that, Congressman. So yeah, I did too, James. I don't blame you. Ratcliffe. In other words, as we've talked about before, much has been made about it's not the Federal Bureau of Matters, it's the Federal Bureau of Investigation. Man, I laughed out loud at that one. That's so funny. It's likewise not the Federal Bureau of Prosecution, right? Nice. So the role of the FBI is to investigate and determine whether or not a subject or target has committed the elements of an offense, and then to refer the matter to the Department of Justice to exercise prosecutorial discretion. Yes, sir. So my question is, since the FBI director, who is a former U.S. attorney, I abbreviated that, former Deputy Attorney General, was of the opinion on May the 2nd that Hillary Clinton had committed the elements of the statute that we have just referenced to, at that point, hand it off to the Department of Justice to play their role. Rybicki: so I don't know. The investigative team certainly would have been working with prosecutors, iterative, right? As any case, right? So meaning what I'm calling the investigative team on the FBI side would have been working with prosecutors at the Department of Justice. And I think as the team is surfacing sort of their opinions and the evidence found, that it would be included in that, if that makes sense. So in other words, I don't think the prosecutors would have been surprised to have seen this. I know it's not directly on point to your question. I'm trying to think it through with you. Ratcliffe: we're trying to understand this as former prosecutors about the role of the FBI. And again, not to reiterate, the conclusion here in the words of the FBI director, based on multiple meetings and discussions with the entire investigative team, was that Hillary Clinton and others apparently had committed the elements of a criminal offense. And why was there need at that point to then go on and exercise prosecutorial discretion with respect to whether or not charges should be actually levied? Rybicki: sure, I see the point. I don't know that I can speak for the director, except to say again, this was the first draft of a statement, right? Checking something here. There we go. And not meant to be final. And so I just want to be careful. I don't want to speak for him as to what he actually, if he felt that he had met this or not, or if that's what he thought the team was thinking. And then Ratcliffe interrupts. I understand that. But I guess what, to the point, the director expresses these opinions that were apparently shared by the team, not once but twice, then goes on, the reason I refer to it as the non-prosecution memo, goes into exercising prosecutorial discretion and the reasons why he would not recommend it, or this team would not recommend to the department that charges be actually brought against Hillary Clinton, despite the commission of the elements of the offense. Is that fair? I think it's fair, except that just, I go back to why I'm not calling this a prosecution memo, because it's meant to be, as he says in there, that this is the FBI's recommendation to, the Attorney General. You notice how the more Rybicki lies, the more he says, or at least maybe not lying, but dancing around the point. Definitely uses that as a time expander to give him more and more chances to make this up as he goes along. If you've noticed that as well, say so in the chat or put in the comments after this post. I want to make sure it's just not something that I'm pulling out of the blue. I think I've seen it as a pattern, but I'd appreciate your comment on that. Ratcliffe: okay, right. But then the FBI. So the FBI director goes on to talk about why prosecutorial discretion and no reasonable prosecutor would bring that case was because, notwithstanding his opinion and the team's opinion that the former secretary had been grossly negligent, that it was going to require something more, that it was going to require intent, correct? I think that's accurate. Okay, so was that a decision that the FBI director had made or the team had made? I don't know the answer to that, Congressman. I would suspect it was a combination, but I don't know the answer to that. Okay, do you know whether or not that was a decision that was made in part by the Department of Justice? Ultimately, or at that point? Rybicki: at that point, I don't know. Ratcliffe: because at some point, the Department of Justice advised the investigative team, apparently, that gross negligence would not be charged and that it would require something more than that, correct? There you go. There you go, right there. The DOJ putting the boot on the neck of the FBI. Let me read that again. That's very important. Because at some point, Ratcliffe says, the Department of Justice advised the investigative team, apparently, that gross negligence would not be charged and that it would require something more than that, correct? Very important. Rybicki: I just want to make sure I got the sequence right. So after this press conference, then the Attorney General convened a meeting. I believe it was the next day, where she was briefed by the Department of Justice on the statutes, and then they agreed that no charges should be sought. Wow. So, why did you continue with the investigation? It's like Mueller saying that he had no way to charge the president with a crime because the president would not be able to defend himself in court, since Mueller felt it was a hard and fast rule as opposed to an opinion that you couldn't indict the president. Again, as Barr said, he certainly could have accused him of a criminal offense. He had every possibility of doing that. But Mueller kept investigating anyway, with the assumption that he couldn't do anything about Trump if he committed a crime. If you can't do anything about him if he committed a crime, why are you investigating him? What is the possible point of going on for another year and a half when you have no way of making a case that would stick for obstruction? What was the point? The point was to muddy the waters and give Congress a ladder to impeachment, or a chute, depends on which part of the game you like the best. You know what? I'm going to go with that. Mueller's report, chutes and ladders. That's what that is. That's what I'm going to refer to it as from now on. The Mueller chutes and ladders report. If that sounds too corny, let me know, but I like it. In fact, I love it. I'm very proud of myself right now. La 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 la. Okay. Was briefed by the Rybicki. I believe it was the next day where she was briefed by the Department of Justice on the statutes, and then they agreed that no charges should be sought. Ratcliffe. Let me hand you what I marked as Deposition Exhibit 4. Is that the right number? Are we up to 4? So you can refer to that. And if you go to the second page of that exhibit, there's a chart. And this was a document for the record that was produced a couple of days ago to the House Judiciary Committee in response to a request. But you see under that middle block, in talking about Espionage Act charges, under the statute that I've just referenced, 18 U.S.C. 793F. You can say that with your eyes closed. It's come up so often. Gross negligence. There's a note there that says specifically, DOJ not willing to charge this. So my question, what I'm really trying to find out, is at what point did the DOJ advise the investigative team that gross negligence is off the table? It's going to require something more than that. Ratcliffe continues. Was it on May 2nd? And was that factored into this draft memo that the director had prepared, or did it come at some point in between? Rybicki. Sure. Sorry, Mr. Chairman, if I misunderstood that. I don't know the answer to that. Again, robust discussion about the statutes and the case law, obviously. I want to reiterate sort of my role in all this, and I don't want to minimize it, but, this is all happening in a, whether this was discussed, it may have been, but I'm just not recalling it. Ratcliffe. Okay, but is it fair, again, to say that essentially at this point in time, as expressed by Director Comey, that it was apparently the consensus opinion of the team that evidence of gross negligence was not going to be enough? It would require some criminal intent above that. I think you just said that that was accurate. I believe that's accurate. Yeah, I was just trying to, Ratcliffe interrupts. So in September of 2016, Director Comey was asked in a congressional hearing whether or not any decisions had been made with respect to charging Hillary Clinton before her July 2nd interview. And he said that they had not, that the charging decisions had been made after that date. How do you reconcile that testimony with the fact that gross negligence, more than 2 months before the Secretary Clinton's testimony, was not under consideration, that they had ruled out that in terms of making a charge against her based on grossly negligent conduct? Sir, I don't want to speak for Director Comey on the statement, but how I reconcile it is that the ultimate charging decision for Secretary Clinton in this case was made after her interview in that final conference call. Ratcliffe, with respect to intent, but not with respect to gross negligence. Rybicki, again, I don't want to speak to what Director Comey was thinking when he answered or when he testified to that, but that's how I would. That's how I've interpreted until this point, which is for the whole case, right? Rather than specific elements of it. Okay? One of the questions that you got earlier from the minority staff was about the changes from the word gross negligence to extremely careless. Again, so as of May 2nd, it was the expressed opinion of a career prosecutor who had been a United States attorney and the Deputy Attorney General that Hillary Clinton was grossly negligent, said it not once but said it twice. Ultimately, the final version changed the language to extremely careless, correct? Yes, sir. Media reports are that change came at the request of Peter Strzok, correct? I'm aware of them, yes, sir. Yes. Yeah. And I think And you, I think, testified earlier that you're not sure whether or not he did influence that aspect of the language change. Did I hear that right, or do you know? I do not know. I think at least when we looked at one of these, Ratcliffe interrupts, he said something in here with respects to, for instance, Rybicki interrupts in Exhibit 3. Yup, Ratcliffe Exhibit 3, redacted. Redacted, redacted, redacted. Rybicki. So I wasn't looking at that. I was thinking of the last bullet, number 6 on Exhibit 3, where he talks about topic for further discussion, going to this line of questioning, whether her conduct rises to the legal definition of gross negligence. Ratcliffe, but so I guess to answer, you're not sure whether or not he influenced the decision to change the language from gross negligence to extremely careless. Right. I don't recall him specifically. I do know, again, the team discussed it. So in the team discussion, can you tell me whether or not there was a discussion along the lines of, well, grossly negligent is the exact language in the statute, and if we use the exact language in the statute, people are going to say she committed the elements of the offense. Rybicki, I don't remember again that level. Again, it was just the role I was playing. Well, so can you shed... I have that right. Well, so can you shed any light on who persuaded the FBI director that a change from gross negligence to extremely careless was appropriate or necessary? Do you remember any discussion about why that was? Was there documents that were produced or testimony that was elicited that would have changed his opinion expressed on multiple times in this May 2nd email? Let me just reiterate that grossly negligent was in the original email, as was extremely careless. And then gross negligence was removed and extremely careless was put in its place, or extreme carelessness was put in its place. Because some people have said that extreme carelessness or extremely careless was created to replace gross negligence, and that's not necessarily true. Extremely careless was already in the draft. Why did they remove gross negligence and replace it with extremely careless? That's the question. But it gets a little muddied as people get exactly where those two things came from. So I know it's a minor point, but I think it's an important point that everything is done correctly, that you have the facts straight. This is directly from the IG report, so I just wanted to reiterate that. Ratcliffe's last phrase would have changed his opinion expressed on multiple times in this May 2nd email. Rybicki, I don't. So I don't know whether it first came in as a sort of comment like we saw in Exhibit 3 or, a change in a document or both, or whether it came up in the meeting. I guess I would say, like all of these, it continued to be iterative from the time the director sent it up through when he delivered it as the evidence was evaluated as the case law and the statutes were looked at. And let's remember that, as brought up by the Democrats, this document from May 2nd onward was not always kept track of in a changed document string. Because can't remember exactly what it's called now. Basically, the evolution of the document was not always documented. There were times where it changed without any listing in the change document that had occurred. So procedure was not followed very well in regards to this memo that became the ultimate non-prosecution statement delivered on July 5th of 2016. Ratcliffe. Okay, so going back to Exhibit 3, this email from Peter Strzok to you where he talks about his suggested changes in this iterative process, as you've described it. And if you saw that part of the testimony earlier, almost all of it was redacted. The first 2 segments, at least, were redacted completely. Under number 4, bullet point, he says the statement that, quote, we assess it reasonably likely that hostile actors gained access to Secretary Clinton's private email account is too strong, close quote. And ultimately, we know that the language in the final version on July 5th that was delivered to the public was changed consistent with this, correct? Rybicki, I'll stipulate to that. I don't recall. Ratcliffe, I'll represent to you that it was. Rybicki, yeah. Ratcliffe, my question is, in light of what has now become public about Agent Strzok, and we have all become aware of the intensity of his political opinions regarding both President Trump and Secretary Clinton, are you at all concerned now as you sit here that he played such a prominent role in this iterative process and influenced language changes in the final version of this? Rybicki, I don't want to speculate as to his conduct. What I would offer, though, is my observations of the process, which was it was very much this group, with all those participants weighing in. And so I think it would be very difficult for one person to influence the whole, if that made sense. I don't see how that's difficult, in my personal opinion here. Why couldn't one person come up with an idea that looked good enough for everyone else to agree to? I mean, I know Comey liked to get a lot of input into things and then make his own decision based pretty much on his own feelings or his own regards to the situation as opposed to what the general consensus was. That's been said time and time again. Again, one of the reasons he was such a crappy director. Yeah, again, I just don't see how it's not at all possible, or at least how it would have to be very difficult for specifically Peter Strzok to say to everyone, hey, you know what? Let's just change grossly negligent to extremely careless. Let's bring that up from the second paragraph to the top. That way, we don't have to worry about using that term, since the DOJ has told us they're not going to prosecute on grossly negligent. Why do we even need it in there then? That could have easily been come up with one person and gone along with by the group. Once again, I think Rybicki is being completely disingenuous here. Ratcliffe continues, okay, I'm going to turn it over for you. I may have some, or the chairman. I'll turn it over to the chairman. Mr. Rybicki. Thanks, Mr. Congressman. Chairman Gowdy. Couple of quick follow-up questions. I'm still a little bit confused on whether or not in May of 2016, this draft that you and Mr. Ratcliffe had been discussing, was that the beginnings of a press statement, or was that the beginnings of something that you intended to communicate to the Department of Justice? Rybicki, a press statement. Gowdy. So the decision to appropriate, and I don't mean that negatively, the decision to appropriate the charging decision away from the Department of Justice had already been made? I don't think I would agree with that, Mr. Chairman. I would differentiate it in a couple of ways. So the May email where he starts out saying, I'm trying to imagine what this looked like, right? And so when I say it's the beginnings of a press statement, yes, but not the ultimate decision to go ahead with a press statement, right? Gowdy, when was the decision made? I think you and I agree. I don't know whether it's unprecedented or not, but it's highly unusual for the head of the FBI to have a press conference go into this level of detail about the decision not to charge. Rybicki, yes, Mr. Chairman. Gowdy, Can you think of another case wherein this happened? I cannot. All right? So, unprecedented may be the right word. It's funny how that word gets used against Trump all the time, and then it takes a 10-second Google search to show that Obama did it, Bush did it, Clinton did it, et cetera, et cetera, et cetera. But remember, everything is ATE. Everything is dated after that, and ATE stands for after Trump election. Excuse me. Kitty, you okay? Kitty? Oh, she's gonna get sick. Excuse me just a second. I gotta take care of the cat. Okay, she's fine now. She's she's at my feet right now, as a matter of fact. I'm giving her a little scratch. There we go. She, this particular cat, she's our youngest. She gets very scared when she's about to get sick. It really freaks her out. We have, excuse me, the oldest cat is an old hand at it. It doesn't phase her. She just sits there, makes some noises, gets sick, and then walks away. The middle one basically never gets sick. She doesn't shed either. It's quite amazing. She's a health. She's the healthiest of the three, even though she almost lost an eye when we first had her. She got a sudden and very virulent eye infection, and it took quite a long time to treat it. We had to put drops and salve in her eye twice a day, and that was a difficult time. But her eye was saved. Our vet is incredibly competent. That competent isn't even a good enough word. Yes, kitty cat. Our vet is extremely professional, and they did a great job giving us the right medicine and the right techniques to get her healed. Her eye's fine now. It's been fine for coming up on 2 years, so life is good. And her and the youngest cat are best friends. Couldn't have been a better pairing. Could not have been. Okay, so we're back in. Gowdy, I'll start with him again. All right, so unprecedented may be the right word. What I'm trying to determine is whether or not in May, screwing around. What I'm trying to determine is whether or not in May you knew that the press conference was going to take place, or you just viewed this as a possible contingency. I don't know if I would use the word contingency, Mr. Chairman. I would say it's an option for the end of this. We had, talked about, this in addition to many other options as to, what this would look like at the end. I know at the working level, the team, have been discussing with their counterparts as well, what the conclusion would look like. There he goes again. I would offer, this is Rybicki continuing, I would offer there were several factors that went into the thinking behind the ultimate decision to go with a press conference. And then I would just again reiterate what is my view, that this again is making a public a recommendation, which we would have done in private to the department or in consultation with them. And then the Attorney General convened a meeting the next day where she accepted the recommendation not only of the FBI, but of the career prosecutors. And this is, of course, the Attorney General who had recused herself from the investigation after meeting on a hot tarmac in Phoenix on her private jet with the husband of the subject of the investigation, the target of the investigation, and that would be one Bill Clinton, who was married to one Hillary Clinton, former Secretary of State, current candidate for the presidency, and total target of a investigation that should have led to her being indicted and ultimately found guilty. Jailed? I don't know. I doubt you would put the former Secretary of State in jail, but there's no reason she could not have been found guilty. Seriously, there's just no reason. So because of this meeting with Clinton, where they supposedly talked about golf, kids, and Brexit, there was no one else in the jet at the time, except I believe the pilots who were monitoring the APU, the system that was running the air conditioner. You have to have someone in there when there's anything in the system being run. Can't leave a jet unattended. So she has a secret meeting with Clinton, talks to her legal counsel at the DOJ, and says that they initially told her she didn't have to recuse herself, but she ultimately decided she would, that she would leave it in the hands of her career prosecutors, quote unquote, who were totally under her thumb. And it says right here by Rybicki that the Attorney General, Loretta Lynch, convened a meeting where she accepted the recommendation. So if she was recused, why would she be the one who accepts the recommendation to not charge? Wouldn't it have been up to the lead of the career prosecutors to make that statement if she's recused? Seems like a slight error in narrative to me coming from one Mr. James Rybicki. Gowdy. How many trials did you have when you were an AUSA? Rybicki, I was not an AUSA, sir. Gowdy, you had a trial where you ever had to stand in front of a jury and convince them of something? No, sir. You can imagine how difficult it would be to do that from a prosecutor's standpoint if the nation's premier law enforcement director had reached a contrary decision. So I appreciate the nuance that the Department of Justice still had the option of going forward. The reality is, when you instruct everyone in a press conference that no reasonable prosecutor would take this case, there's not going to be a prosecution. I love Gowdy. God, I love Gowdy. He just cuts through all the crap. Pardon my mouth. Speaking of reasonable prosecutors, there is no reasonable prosecutor that would then take that case to trial. So this was more than just a recommendation to the Department of Justice. Will you concede that? Mr. Chairman, it might be my simplistic view. I mean, and again, not having done trials, there we go. I take it for what the director, intended again to recommend to the Attorney General. Now, perhaps, again, the view might be that, it would be hard or impossible, in your view, to take the case at that point, but Gowdy, certainly be a challenge. Rybicki, I would only offer, I think, whether it was, for instance, if it was not made public, if it was just the FBI's private recommendation, I still think the recommendation would have been the same. I don't know if the result would be the same as you indicate. Gowdy, but that is a big distinction because it's usually done in private. This time it was not done in private. Rybicki, yes. Excuse me a moment. Check. Okay. Gowdy, and I'm trying to determine whether or not whatever factors led to the director to take this unprecedented step, whether those factors existed in May of 2016. Whatever caused him to think we're going to do this differently, would you concede that the meeting on the tarmac, well, actually, it couldn't have been a factor because it took place after May? That's correct, sir. So what factor existed prior to May that led the director to take this unprecedented step? So there's at least two that I'm aware of, but to elevate it to just one step, I would say his overarching concern was the integrity. So he's articulated three sorts of spheres. One, the FBI's integrity, right? That people know that this investigation was done in a professional way with integrity. Number two, the Department of Justice's writ large, right, which the FBI is a part of, that people have confidence that the Department of Justice is operating in a professional, apolitical way. And then number three, the confidence in the criminal justice system, again, writ large, that people have confidence that the system is operating the way it should be. So that's what he's articulated before his overall thinking. And they stop for a break. Let me stop you and then let's sort of backtrack for a second. Okay, so we're at page 116. I said page 120. I think they've still got quite a bit of time. For the Republicans have quite a bit of time for their questioning. So, yes, kitty cat. So let's leave it there. We'll start again tomorrow at 10 a.m., just like today, just like for the rest of them. And except, of course, for last Friday, but that was a very, hopefully, unique situation. And just one last thing. Let's again keep our eyes out for the AG report. I have a feeling if it's going to come out this week, it's going to come out either Tuesday or Thursday. I think this is too big to let drop on a Friday at the end of the news cycle. I just don't see him doing that. But that's a complete guess on my part. So if it does come in, what I'll do is, assuming it comes in tomorrow, for instance, what I'll do is I'll finish that day's reading, and then I will do the IG report. Now, this is the only 2-day reading. This IG. I'm sorry. Thank you, sweetie. IG report. This is the only 2-day testimony that we've got this week. We've got Gia Colon on Wednesday, which is 146 pages, and Taskas on Thursday, which is 173 pages. So worst comes to worst, they'll get bumped to the next week, and everything after them will get bumped down accordingly. And let me just state one more time, no matter how long the IG report is, I will read it into the record. The only part that I would skip would be anything that's completely to do with legal precedent and case law. There's no reason for me to read that in because I'm not a lawyer and I wouldn't understand it at all. I would just be babbling, much like I am right now, but even worse. So let's just leave it at that. Also, if there are any appendices, I usually don't go into those. I leave that up to you. Of course, the full link to the full report will be in the description of the videos. So there we have it. Thank you so much for your attention. Jason, so glad you showed up. Very nice. Picasso knows, once again, keeping me on my toes, keeping me from getting too much into the weeds with regards to my making stuff up as I go along. My thanks to you both. My thanks to all of you who are out there watching or listening, possibly watching, and all of you who will pick this up after it posts. Again, comment section is your friend. Use it at your discretion, but I very much encourage that you come in. Also, if you wouldn't mind liking the video, I know these are not very popular, but any likes that you give it will help raise it up a little bit in the algorithm, and perhaps other people will see it and they'll start tuning in as well. So you are a big part of this process. Just keep that in mind. You are the process. I'm just a guy with a voice and a computer monitor. You people are the ones who are important. So again, thank you. I'll see you tomorrow morning at 10 o'clock. So long.